Yes.
Item 31, Your Lordship, this involves National Information Commission.
31.
Yes,
Okay, I may not be able to take this.
my lord, that is what. So I'm bringing that let it come up after the vacation.
Yes, item 31. List this matter before any other bench without me. After the vacations.
Much
After the
obliged.
summer vacations.
May I please, Your Lordship?
Yes.
I beg to mention item number 10. Item number 10.
Yes.
In this case, Jain Sahewala, senior advocate, he is appearing on behalf of petitioner. His brother expired recently, so kindly adjourn the matter for today, Your Lordship. Any date, Your Lordship.
1 week? After a week?
2 weeks. Okay. 2 weeks. 2 weeks.
I think then, learned counsel, you are Mr. G. Deka.
R. Kaman. R. Kaman. Kaman. K-A-M-A-N.
Mentioning on behalf of the senior counsel, S.N. Sahiwala, has submitted that the senior is in bereavement and accordingly to list the matter after 2 weeks. Prayer is allowed, list the matter after 2 weeks.
Obliged. Obliged.
Yes.
Please, Your Lordship, I beg to mention item 6. Your Lordship, kindly grant us 3 weeks time to file a reply.
Adjournment counsel for the petitioner, MS Research, prays for 3
3 weeks, Your
weeks
Lordship.
time to file a reply to the affidavit in opposition filed by the
Respondent 4 and 5.
by the respondent number 4 and 5. Prayer is allowed. Learned government advocate K. and Rami and learned counsel such for the respondent 4 and 5. Respondent number 6, 7, and 8 are present. It's the matter of the 3 weeks.
Much obliged. Please, Your Lordship, I beg to mention item number 7. Your affidavit has been sent for vetting, Your Lordship, so if the matter can come up again after 1 week.
I'm sorry. Government counsel and Ms. Such prays for how much time?
1 week, Your Lordship.
1 week to file the affidavit in opposition as the same has been sent for vetting. Prayer is allowed. List the matter after 1 week. Learned counsel for the petitioner. No one.
Your Lordship, I've taken his consent.
Okay. Don't say anything after 1 week.
Your Lordship, item number 15. Here pleadings are complete, Your Lordship. So if it may be listed for admission, for hearing, Your Lordship, in the regular course of hearing.
Next week, if it can be disposed of, because the matter is only with regard to, so far as the facts are concerned,
Usual course.
we can dispose it at admission stage. Leadership. Next week,
What is the matter
Thursday.
about?
The matter is about posthumous regularization. So far as the facts are concerned, they have admitted that I am the senior most. But the only thing that remains is whether the case in Neshivi has an overriding effect on all posthumous regularization, which we are asserting that it is not, because the facts are different. And Neshivi is a judgment in personam; it cannot be a judgment in rem.
It is submitted that the pleadings are complete in this matter and accordingly to list the matter for admission hearing.
Next week, 19th, if that can be accommodated.
Accordingly list the matter on let it be 20th.
20th.
26.
Much
Obliged.
Full motion, item number 1.
May it please your Lordship. Lordship, this IA is filed praying for impleadment of the Commissioner and Secretary, Department of Work and Housing, Nagaland Lordship, Government of Nagaland Lordship. Lordship, here in the main petition, Lordship, here the state government, the Mort Lordship has put the responsibility upon the state government, and in the arbitration, the chief engineer is the only respondent. And Lordship, in fact, As far as the state is concerned, the chief engineer is not the independent authority. So if the commissioner and secretary can be implemented as a party in the main arbitration petition, Lordship.
In the main petition,
Lord-
Commissioner Secretary is not the party.
No, Lordship, only the chief engineer, Lordship.
This application has been filed and praying for impleadment of the Commissioner and Secretary, Government of Nagaland, Department of Works and Housing as respondent number 3. So, Learned Counsel for the petitioner submits that in the main petition, the Commissioner and Secretary, Government of Nagaland, Department of Works and Housing has not been implemented as a party. Stop. In the contract agreement, the language is clear that the Ministry of Road Transport and Highways is represented by the Chief Engineer PWD, National Highways, Kohima, Nagaland. Stop. However, the MORTH, through the Undersecretary to the Government of Nagaland, has addressed a letter to the Secretary Works and Housing, Government of Nagaland, white letter dated 2/4/2024, by throwing all the responsibility upon the state PWD Nagaland with the stand that any financial implication or claims made by the contractor is to be borne by the state agency. Stop. As far as the state respondents are concerned, the chief engineer cannot take an independent decision on behalf of the state. Stop. Therefore, the petitioner, as a measure of abundant caution, has prayed for impleadment of the Commissioner and Secretary, Government of Nagaland, Department of Works and Housing, Nagaland, Kohima, as respondent number 3. Stop. Upon going through the pleadings, stop. This court is of the view that the Commissioner and Secretary, Government of Nagaland, Department of Works and Housing, Nagaland will be a necessary party in the proceedings. Stop. Accordingly, the prayer is allowed and the petitioner is allowed to implead the Commissioner and Secretary, Government of Nagaland, Department of Works and Housing as respondent number 3. The petitioner shall amend the cause title accordingly and take steps for notice on the respondent number 3 by registered posts with AD as well as usual process. List after 3 weeks.
Lordship, 2 weeks.
Take 2 weeks.
Much obliged, Lordship.
Yeah, I this one.
For admission, item numbers 3 and 3 to 4.
Please, Your Lordship. Your Lordship, we are ready for admission hearing, so if it can come after listed matter.
All of the orders.
For admission, item number 5.
May I please, Your Lordship? Your Lordship, here, the petitioner is praying for minimum scale of pay. And by the office memorandum brought up by the government on 5th March 2025, the case of the petitioner can be covered. Your Lordship, in light of this, the case of the petitioner can be closed.
The application is on record.
Your Lordship,
It has addressed
Yes,
your
Lordship.
grievances. The state respondents have issued an office memorandum number AR-3/GAN-67/2001 dated 5th March 2025, by which it is provided that the it's provided that on the recommendation of the Nagaland Work Charge and Casual Employees Commission, in pursuance of the cabinet decision conveyed by letter number CAB-1/1423 dated 25th February, you just reproduce this. So, the Learned Counsel, Ms. Levika, appearing on behalf of
For all the contempt,
all the contemners, has submitted that the grievance of the petitioner has been addressed by this office OM dated 5th March 2025.
Your Lordship, it can be
It
addressed.
can be addressed by the office OM dated 5th March 2025, and accordingly the present petition may be disposed of. Present contempt petition may be disposed of. Stop. The learned counsel for the petitioner has no objections to the same. Accordingly, the contempt petition, present contempt petition is disposed of.
Lordship.
For admission, item number 8.
Your Lordship, I received an instruction, Your Lordship, wherein the case of the petitioner, Your Lordship, the vexation and as well as his promotion, Your Lordship, it has been sent up, Your Lordship,
Has been,
sent up, Your Lordship, to government, Your Lordship. Actually, in the present case, Your Lordship, the promotion is not an issue here. However, Your Lordship, it is going together, Your Lordship. That is the instruction I received. Your Lordship, sometime may be granted to me so that I can file this in my affidavit, Your Lordship.
this is regarding fixation.
Yes, Your Lordship, there is an error, Your Lordship.
How much time?
Your Lordship, 3 weeks will be granted so that I can file, Your Lordship.
Government Council, Ms. Levika, for the state respondents. It is submitted that she has received instructions that the fixation, that the pay fixation of the petitioners is being addressed, and the same has been processed to the government.
Yes.
So accordingly, she has prayed for some time to receive instructions and will file an affidavit to that effect. Stop. Prayer is allowed. Please the matter of the
3 weeks, Your Lordship.
3 weeks. Stop. Learned counsel for the petitioner is present.
For admission, item number 9.
May I please, Your Lordship? My Lord, I am appearing through VC. My Lord, am I audible?
Yes,
Please, my Lord. Lord, on the last date of it, this is the petition for appointment of arbitrator, my Lord.
yes.
And my learned friend is to seek the instructions. However, I am relying on the Honorable Supreme Court judgment that after the filing of the petition, Lord, either the petitioner or the respondent, their rights have ceased. Only the court is the right person to appoint the arbitrator. So in view of that, my Lord, I have already circulated one judgment of Honorable Supreme Court, 2006, 2 Supreme Court cases, 638. So my Lord may appoint the sole arbitrator or any retired honorable judge of this honorable court.
Okay, this Punch Lloyd Limited.
Yes,
Honorable
Punj Lord Limited. Yes, my Lord. Para number 5. When judgment of my Lord Datta Switchgears Limited has been relied in this paragraph, I am Lord reading the sub-para. So far as section 16.6 is concerned, if one party demands the opposite party to appoint an arbitrator and the opposite party does not make an appointment within 30 days of the demand, the right to appointment does not get automatically forfeited after expiry of 30 days if the opposite party makes an appointment even after 30 days of the demand, but before the first party has moved the court under section 11. That would be sufficient. In other words, in cases arising under section 11(6), if the opposite party has not made an appointment within 30 days of demand, the right to make appointment is not forfeited but continues, but an appointment has to be made before the former files application under section 11 seeking appointment of an arbitrator. Only then the right of the opposite party ceases. So, my lord, here the right has ceased, my lord. So I'll request this honorable court to appoint any retired honorable judge of this honorable court as the arbitrator, my lord.
Yes.
Please, my ladyship. Yes, I'm not disputing on the judgment later by the Honorable Apex Court. However, since a process has been followed by the government and it takes time, that is why the arbitrator could not be nominated on time. However, here coming back to the sole arbitrator, even if the two nominee by the two parties, even if they go for appointing the sole arbitrator or arbitral presiding arbitral arbitrator, process will be more or less the same. Now the government is comfortable with the process they have been followed. Again, because they have to reroute to letting process within the government. So
what process was that?
like they have to appoint the government nominee. It has to route it through the directorate, then to the government level. That has taken time.
Meaning suggesting
Yes.
the person
Yes.
to be appointed.
Yes. So, but if my learned friend is,
No. We will pass necessary order and then give conditions. You said that you wanted in Kohima, isn't it?
yes,
So court will
Yes,
say,
we will come to Kohima, my lord, for the arbitration. No objection.
and then PK Sharma will appoint Mr. PK Sharma, retired judge.
Grateful, my lord, grateful.
Is that okay?
and the department, what the department is also insisting is they have also not explored the possibility of arbitrary tribunal still. So if that is the case, I still pray for a more few days.
No, my lord, may kindly see the previous orders. Kindly see the previous orders.
So much opportunity has been given to you.
Yes,
So many days.
And in item number 1 today,
Yes.
if that is the order passing, that also has to be followed, then there has to be suggestion only has to be made by the court. All these things are there. This is the order pass in today's item 1. That is also
No, on the last occasion also, I think we had suggested for Mr. PK Sharma, and then you were supposed to get the instruction, isn't it?
yes,
Whether they're agreeable. Was it in this case or the other
in
case?
the other. No.
no, if this was the case, my lord, but the honorable judge name was not mentioned. It was only mentioned that let it be for the sole arbitrator. On that point, my learned friends sought the instructions that they will seek the instructions. However, the name was not my lord,
It
put
was not
forward.
mentioned, yes.
Yeah, but the my lord said that it will be referred to the sole arbitrator of the any retired High Court honorable judge.
So do you have some other names you can suggest?
Yes. So kindly grant me
No, my lord, no, my lord.
Tomorrow,
My lord, it's being adjourned since long only on this aspect, my lord. That
No.
instructions.
Yes,
So, my lord,
instruction, but that is not, we are not solely responsible. We have been working behind this honorable court.
my lord may appoint any arbitrator, my lord. We have.
court is suggesting Mr. PK Sharma, but it's up to you. The
Yes.
government
I'm agreeing on that.
petitioner is agreeing to that. So tomorrow, okay, we'll dispose it.
Oh.
Yes, tomorrow.
Grateful, my lord, grateful.
for admission, item number 11.
May it please the lordship. In this case, my lord, I have filed the application for quashment of the FIR, and during the pendency of the this petition, the charge sheet has also been submitted. So it is now, my lord, is very clear. Perhaps scan copy of the LCI.
Your ladyship,
Can copies.
yes, regarding item 12 and 13, these are connected matters, your lordship, though it's FIR is different. Your lady here in this, yes, item 12 and 13, I'm yet to receive the up-to-date status, your lady. So
All are
every
different
time
case,
may
there
be
is no, my
granted.
lord, connection with each other. But for the convenience,
Different FIR. Modus operandi is same. In all the three cases.
And this one is
32,
here
Yeah,
95
so
is
that
for
is-
32.
yes,
this is
32.
11, perhaps. I don't
In
know
that
why-
case, it has been charge sheeted.
This is,
However, in the other two cases, that I'm yet to receive the up-to-date status.
we cannot separate it.
This can
Uh,
be separate.
Can we hear this today?
Your
Since
lady.
the records are also here.
lady,
But
if
all
that-
three are different, I guess, different PSP.
Different people.
And different
different PS.
informant as well.
Okay, okay,
different
okay,
inform-
different
yeah.
inform-
But then for the convenience, my lord, the matters have been fixed on a particular day so that it is become convenient for attending. Otherwise, there's no, my lord, interconnection with either of them. Well, the petitioner, he is my lord, a businessman having a my lord, sanitary and hardware my lord, showroom as well as dealership at Gauhati.
Your lady, at least a week's time, your lady.
Have we called for the records of the other two cases also? Whether it's come. Check. 12 and item 12 and 13. Perhaps PP was allowed to produce the CD.
CD,
Scan
yes,
copy,
yes,
ah.
CD. But if it's charge sheeted, then
The other two,
the position will be
12 and
different.
13, charge sheet has not submitted. 11 submitted, my lord, we have also brought on record this charge sheet, my lord.
Direction is there to produce the CD.
CD.
Yes. So
CD is already here, but my only apprehension is if it's charge sheeted, then without calling the records and disposing will not be proper. That's what my,
Charge sheet, in fact, is not the material for, because it, the FIR, we are seeking quashment of the
yes,
FIR.
yes, that's true. your
So it is
lordship.
prior to the charge sheet. When charge sheet is submitted, that aids the court or to decide whether the grounds what we, on which the FIR is being challenged is supported or not. That much. we get. But anyway, if she needs some time, a date may be fixed.
1 week.
Yes, a week's time will do.
My lord, only one thing, my lord, so far as item number 11 is
Yes,
concerned, my
yes.
lord.
Little case there it is.
Well, so far as item number 11 is concerned, the charge sheet having been submitted, my lord, I pray that at least the proceeding of that case, my lord, till the next date may kindly be stayed.
Think we heard about now together. After we came, this is, no, after we got it, so I will do what this one. Just to get confirmation whether they have just.
The problem is again on the next day, if you say that it's charge sheeted, we have to again call for the records from the GMFC. Huh?
Yes, yes. That's why it will be proper if the charge, if the LCR is called, if it's charge sheeted. If not, then the matter can be proceeded. That's what I'm praying before this court.
In case charge sheet has
So
been
just a
submitted, in
week's
that
time
case,
to
PP will
confirm.
produce the, my lord, scan copy of the
Yes,
record.
and copy can be produced.
Instead of calling by this court
Yes,
from
yes.
the trial court, the PP
Yes,
will
that
have
also can be
produced
done.
the, my lord,
That-
Yes,
that-
just that I didn't get confirmation regarding the status. That's why.
Okay, item 11, item 11, okay. Lord Learned PP is Murray. And also the Learned Senior Counsel, Mr. Vijay Saikia for the petitioner. The trial court records have been received. Stop. However, Learned PP submits that in item 12 and 13, she needs to ascertain whether the matters have been charge sheeted, and therefore prays for a week's time to obtain necessary instruction and also the records of the trial court if charge sheeted. So, prayer is allowed. What were you saying about 11?
My lord, 11, at least till that day, my lord, the proceeding in the trial court may be stayed because the charge sheet have been submitted, my lord.
In item 11? Okay, you separated, okay? This is the only item.
Yes,
In the criminal petition 32 of 2024,
My lady, I'm
Yes.
appearing for the complainant in item number 11. The petitioner is enlarged on bail. Uh, the stage before the trial court is CC. So I think staying the proceeding, it won't be in the interest of justice, my lady. A date may be fixed where the entire case may be settled at once. Because he's already on bail, my lady.
Yeah, how does it prejudice? Yes.
Yes.
My lord, when I'm my lord, challenging the very my lord, FIR itself, my lord.
The next date is next month.
Initiation of the my lord, proceeding itself.
Before the
that-
trial court.
Before
Yes.
the next date, we'll try to dispose it off.
I'm not very sure till which date it has been fixed.
When is it fixed?
26 or 27.
Of this month,
Of June,
July.
July,
July.
July.
Yes.
That will not prejudice the either side also, my lord, because evidence has.
Yes. Seven.
It's fixed for 24th of July.
It's okay, we'll state in. Learned counsel for the petitioner, learned senior counsel for the petitioner has prayed that the proceedings before the trial court may be stayed till the next date, since the matter is already charge sheeted. The proceedings of the
GR case number 95 of 2024.
95
Of 2024.
So accordingly, state till the next returnable date. So fix the matter on. Give a date. It is
21st, 22nd July.
the learned PP is praying for 1 week
A
only.
week time.
So let it be on 19th next week.
It's,
19th.
owing to the personal difficulty.
Okay, then what about 23rd June?
Twenty-third.
23rd June. Then item 12 and 13, separate order, okay? The learned PP has submitted that she has to receive instructions as to whether the charge sheet has been filed. Stop. And accordingly, prays for some time to obtain instructions. Release the matter on 24th June. And in the meantime, the learned PP shall obtain the updated case diary. And if charge sheeted, scan copies of the trial court records.
Yeah.
It's not 24th, all three of together.
We have all agreed for 26th, my lord.
26th,
Logic.
okay, 26th June.
Always.
For admission, item number 14.
May I please, Your Lady, Your Lady, grant me 2 weeks' time to obtain the status report.
Lordship, I am for the petition.
Respondent two. Who's appeared for
As for
respondent?
petitioner, my lord.
None appears for two, no? Twelve of records are here.
Up to date CD.
CD.
Yes.
Learned PP is Mary prays for some time to receive the scanned copy of the updated CD in the present case. Learned counsel for the petitioner, such and such is present. So is the matter on,
After 2 weeks.
is the matter after 2 weeks. On which date the learned PP shall obtain the scanned copy of the updated case diary.
Grateful.
Not so bad. For admission, item numbers 16 and 17.
May I please, Your Lordship. Your Lordship, by the last order, Your Lordship, this honorable court has observed that if no instruction was received, this matter can be disposed of, Your Lordship, on the admission stage. However, Your Lordship, I have not received instruction, but I received a telephone call telling me to request this honorable court to seek some time because the instruction is awaited. So if this honorable court can be gracious to grant some time, Your Lordship, so that the instruction will be placed on record, Your Lordship.
Pending bills.
Yes, Your Lordship.
Lordship, more than 6 years have been passed, and the amount is also not that much also, Lordship. And by order dated 6/2/2025, they were given the last chance. After that also they took, this case was listed for 4 times, Lordship.
Yes, Your Lordship, we understand the problem of the petitioner also, Your Lordship, but since there is a procedure, so we're having some difficulties, so this honorable court may be gracious because they have asked me to request this honorable court to grant some time, Your Lordship.
There's only 2,54,000.
Yes, Your Lordship. So this honorable court may be gracious, Your Lordship.
Just get instruction as to whether they are admitting this liability or not.
That,
That's all.
Your Lordship, that they admitted, Your
Ah,
Lordship. However,
then-
like for releasing, I mean, like,
Lordship,
Thank you.
completion certificate was also issued to us.
No, we'll dispose it and then give you enough time.
Your Lordship,
Oh.
that was
Make the
also of the
payment.
view, but since there was no instructions, Your Lordship, I'm, yeah, like disabled, Your Lordship, at this moment. So at
1
least
week,
sometime,
1 week.
2 weeks, Your Lordship, maybe gracious, Your Lordship, 2 weeks.
You have to
Humble
get the
prayer.
instruction
Yes,
from where?
from the,
Kohima only.
no, yes, from Kohima only, Your Lordship, but from the PHQ, they have the sort instruction from the government, Your Lordship. This honorable court may be gracious, Your Lordship.
Learned counsel for the state respondents, Ms. Rebecca has paid for 2 weeks' time to receive instruction. So, it is observed that this court at which order?
15/5/2025. There was an observation by this one. The last order.
This court on 15/5/2025 had given 3 weeks' time to the government council to obtain instructions indicating that this would be the last opportunity as it is an admitted liability, and that the court will dispose of the present application on the next date. So, however, when the matter is called, learned government council submits that there is some formalities.
Yes, Your
that
Lordship.
has
Some instruction has been
formalities
awaited, Your
and
Lordship.
certain instructions are awaited from the government level. So accordingly, she has prayed that she may be granted 2 weeks' time as a last chance. The learned counsel for the petitioner has objected to the prayer for adjournment. So, however, in the interest of justice, the government respondents are granted another 2 weeks to obtain specific instructions regarding the admitted liability and also instructions as to how much time will be required to clear the pending bills. It's the matter of the two weeks.
Obliged lordship.
Apology, my lord. My lord, I beg to mention item number 28, lordship. Lordship, here I received the CD, however, FIR has not been annexed. And contention of the petitioner is that FIR has not been registered. So lordship, I may allow some time to
Hearing
get
matter.
hearing matter, lordship. Item 28. So if this matter can come up on 26, I have taken the consent of the office.
Item 28. Learned PP, please remove me submits that he has received the
Case
CD
diary.
case diary.
How,
However, the FIR has not been annexed along with the case diary. Accordingly, he prays for some time to receive the copy of the FIR. Learned Senior Counsel, Mr. PG Sakya, hearing for the petitioner assisted by Mr. Such and Such is present and has no objections to the prayer for adjournment. List the matter on 26th June for hearing as a fixed site.
The interim order passed and
The
admitted.
interim order passed earlier shall continue till the next week.
Obliged.
for admission, item number 18.
Was that- can you endorse?
His lordship, my lord, I've received the CD, man.
Is this pre-arrest?
Yes, lord.
Acha, acha, okay. So what is the IO saying?
My lord, petitioner was appeared on 28/5/2025, and the statement has been recorded, my lord. Page number 6, your lordship, kindly see the statement. Page number 6,
Page,
8.
page 8, I think.
Yes, yes, page 8. The petitioner statement is.
So are you objecting or not?
My lord, I'll leave it to your lordship, my lord, since
And the other person, his statement is, okay, page.
page number 6.
Both the applicants appeared on the same day, Lord.
And what about the other accused? Because their statements, only two statements are here.
Yes, the accused number 1, that one in the, it was listed last week, and that during that petitioner has submitted that they have moved SLV before the Supreme Court. That is why the matter has been adjourned for 3 weeks, my lord. And here only the 2 accused are there.
During that time, during the pendency, they have not examined.
No, already recorded, my lord. Already recorded. Oh no, my lord. No. That accused number 1, he was not interrogated. Statement was not taken because he was notice was issued to appear, but his wife has submitted the letter. Your lordship, may kindly see the last page, page number 21.
Okay.
This is the letter
Second,
submitted by the accused wife. That is why his statement could not be recorded.
In that case, I think it would be better to take up all the matters together. The three matters. When is it listed? The other one?
It will be listed after 3 weeks, my lord.
Because there is something which can only come to light after examining the
Yes.
case number one.
My lord, as per the city, only the statement has been recorded, so
Yes.
sufficient time may be given, my lord.
Otherwise, your ladyship, it appears that both the applicants, item number 18 and 19, they are cooperating with the investigating agency. It's also very clear that there are no criminal antecedents.
No, that is there, but the case number one has not been examined.
Yes, I agree
And
that. I
there
agree
may
that.
be some discrepancies, contradictions if
Yes.
the accused number one is also examined. And in that case, the investigating authorities may need to go for a joint interrogation also.
Lodge. In that case, may I pray that interim may be considered till such time, at least that interim protection. Because it's clear that I'm cooperating with the investigating agency. I have appeared on 28th of May.
What is the other case number, the other one? Secretary petition number. For case number one.
My lord, I have
Yeah,
not put the file,
You
so,
you just supply the number, okay? Later.
okay.
Mm. Mr. Mohammed Jamir, counsel for the petitioner, and Mr. Deepak Gom, learned PP for the state. Respondents, stop. Learned PP has produced a scanned copy of the diary, the case diary. Stop, and the same has been produced. Stop. From the case diary, it appears that the petitioner was examined by the IO on
2805.
28/5/2025. So, and his statement has been recorded. It is seen that the petitioner has been cooperating with the investigating agencies till date. So, however, the statement of of the accused number one in the FIR is still to be recorded, as he has not appeared before the IO due to the pendency of the anticipated bail application number that you just leave a blank before this court. So accordingly, the present petition along with anticipatory bail application number such and such.
My lord, anticipatory bail number 19 of 2025. It is mentioned in the letter.
19 of 2025
Yes.
on in that petition, I think 2 weeks were given, or 1 week.
3 weeks.
3 weeks was given.
Yes.
So that will be in the 3rd week or 4th week, June. Or just say along with anticipatory bail application number 19 of 2025. Is in the 3rd week of June. Of 2025. Stop. In the interim, it is directed that the present petitioner may be released at interim bail in the event of arrest on executing a bail bond of rupees 30,000 to the satisfaction of the arresting authority. Stop. However, the same is subject to the outcome of the main hearing. So this is the matter accordingly.
Similar order may be passed in the next.
This next item, similar.
Much obliged.
You will take this back or?
No, no, it's okay. Extra copy.
For orders, item number 20.
May it please Lordship. Lordship, in compliance of this honorable court's order, I have taken steps upon the sole respondent by way of register post on 9/5/2025.
Service report awaited. Also for the petitioner, Shrimad Jim is present. So steps have been taken for service on the respondent by registered post with AD. However, the written service report is awaited. Accordingly, this is the matter of the 3 weeks awaiting service report on the respondent. So respondent.
Sole respondent. Much obliged.
For orders, item number 20 and 22. Item number 21.
21 and 22.
Please, Lordship. Lordship, as per the previous order dated 1/5/2025, we have taken steps upon the respondent. And as per the office note, respondent number 6 has filed its Bagalatama. However, the claimant and the respondent number 5 are yet to appear, Your Lordship.
The 6 is the insurer.
No, we are the insured.
Then who is respondent number 6?
Respondent number 6 was included in the claim petition, Your Lordship. But I believe the respondent number 6 was not.
6 is, it means Tata Motors Insurance.
Yes, Lordship.
Office note dated 5/6/2025 indicates that Vaklanama has been filed on behalf of the respondent number 6. So, however, service report is still awaited in respect of respondents number 1 to 5. So, this is the matter after 3 weeks.
2 weeks, madam.
It will be 3 weeks.
Okay.
3 weeks awaiting service report on respondent number 1 to 5.
Right, madam.
For orders, item numbers 23 and 24.
Your Lordship, as per the office note, the service upon all the respondents are awaited.
Waited.
Yes.
Only counsel for the appellant is present. Office note dated 6/5/25 indicates that service of notice on all the respondents is awaited. So accordingly, this is the matter of the 3 weeks.
Much obliged, Your Lordship.
For orders, item number 25.
This steps taken.
Yes, Lordship.
Attorney counsel for the appellant, Mr. Ketuvi is present. Office note dated 28/5/2025 indicates that notice on respondent number 1 has returned unserved with the remark insufficient address within brackets. The appellant is directed to you try to get the correct address.
Your Lordship,
Because it has written.
we have filed according to the case record.
Because such and such residing at Mokchung town, that alone, how will it reach?
That is addressed that during the time of claiming this MSC, Your Lordship. This is the address.
Then in
the
that
address
case,
part
you may have to go for paper publication.
of- Your Lordship.
And serve with the remark insufficient address. No? So the petitioner is, the appellant is directed to take steps for, or we can wait for some time,
Okay, Your Lordship.
delete that sentence, say await service report and list after 3 weeks.
Your Lordship.
For admission, item numbers two,
May
three,
it please your
and four.
lordship. Item 2, 3, and 4 is for disposal, your lordship, and since part heard is pending, precedence may kindly be given to part heard at item number 26, my lord. Only clarification is required. No long submissions will be made.
Okay, that part heard matter.
Yes, your lordship.
For hearing, item number 26, part heard.
Who's that?
Please, Your Lordship.
Yes, did you receive the instruction?
Lordship. Lordship, accordingly, I informed that Lordship, the respondent number 5 was appointed under the executive engineer PWD R&B Atos Lordship.
So in the office of the EE,
Lordship.
not the SDO.
Yes, Lordship. We have also clearly seen from the annexure C of page 18, read petition.
Your affidavit,
No, Lordship, read petition,
petition.
page 18,
Page-
annexure C.
Yes, where's Ms. Zimomi?
I beg your pardon, Lordship. Due to some circumstances, she's running late. So
We have to wait then. We have to wait for some time. We cannot dispose it off without the petitioner.
I pledge.
Just- On the admission.
For admission, item numbers 2, 3, and 4.
My please, Your Lordship.
Yes.
Lordship, in this case, the petitioners are praying for regularization, Your Lordship, as well as scale of pay, Your Lordship.
This is the PPC 92.
Yes, Your Lordship. We have filed an amended petition, Your Lordship.
This is also landowner.
Yes, Your Lordship.
Let's see, thank you, sir, please.
Yes, Your Lordship. So, Lordship, the petitioner was appointed in the year 2007, Your Lordship, on contingency basis. Now, Your Lordship, at that point of time, the memorandum, the policy which was holding the field for landowners was 91, Your Lordship, which is at page 15, Your Lordship, in my petition. Lordship, at number 5, Your Lordship, grade 4 post, if I may allowed to read, Lordship. Direct appointment should be made by the appointing authorities from amongst the landowners whose ownership of land is certified by the Village Education Committee and local administrative officers, Your Lordship. So, Your Lordship, my case is that I should have been appointed on regular basis, Your Lordship. However, my appointment was on contingency basis. So, aggrieved, Your Lordship, I approached this honorable court earlier, Your Lordship. The order is at page 22, Your Lordship, by filing WPC 192K of 2017, Your Lordship, at page 22. Lordship, it is a short order, if I'm allowed to you read, Lordship. This is a writ petition praying for issuance of appropriate writ or direction directing the respondents to regularize the service of the petitioner as Chokidar cum sweeper in the GHS New Land District, Dimapur, Nagaland, and also to give her regular pay scale with retrospective effect. It is submitted by Mr. Such and Such that the petitioner was one of the landowners of the land on which the school, namely GHS New Land, Dimapur, was constructed and established. Therefore, as per the government scheme issued by notification dated 5/8/91, she was appointed as Chokidar cum sweeper on contingency basis, and thereafter her service has continuously been extended from time to time. The Land Council further submitted that, as per the scheme, the landowner are to be appointed on regular basis, but the petitioner was appointed on contingency basis, which is in violation of the scheme. Therefore, the respondents may be directed to appoint her on regular basis as per the scheme. Mr. Such and Such also submitted that an employee appointed on contingency basis are entitled to scale of pay. Therefore, the respondents may be directed to give her scale pay with retrospective effect for at least 3 years. As per the scheme, the Village Education Committee appears to have recommended the petitioner's case being one of the landowners. Further, it also appears that the claim of the petitioner was also recommended by the principal of the school. And lastly, the additional Deputy Commissioner, New Land Dimapur, had also certified to the effect that the petitioner is serving as Chokidar cum sweeper of the GHS New Land and is one of the landowners on which the school is established. In view of the documents stated above, which supports the petitioner's claim, this court proposes to dispose of the writ petition with the following direction: that the respondent shall dispose of the writ petition of the petitioner in consonance with the scheme within a period of 2 months from today. So, Lordship, after this, Your Lordship, the impugn order was issued, which is at page 24, my Lord, next page. If I may be allowed to read, Your Lordship. With reference to the subject cited above, it is regretted to inform you that the department is not in a position to consider your representation in consonance with the government scheme 5/8/91, as you cannot claim the right to be treated equally with other employees appointed on landowner basis, as they were appointed against a sanction post, whereas in your case, your appointment is on contingency basis without a sanction post. But this is the case, Your Lordship. So similarly situated persons were appointed on regular basis, and they're saying that since my appointment is on contingency basis and not on sanction post, my prayer cannot be considered, Your Lordship. However, Your Lordship, my case is that the 91 policy is clear, the memorandum is clear. All the landowners has to be appointed direct recruitment regular basis, Your Lordship. However, I was appointed on contingency basis, Your Lordship. Now
you're
you
still continuing on contingency.
Yes, Your Lordship. Now, Your Lordship, the government has filed the affidavit, and they are relying on memorandum dated
2018.
Yes, Your Lordship. Now I'm saying that 2018 memorandum does not cover my case, Your Lordship, because I was already appointed, Your Lordship. And it cannot have retrospective effect on you, Your Lordship. And even the impugn order is prior to the March 2018 notification, Your Lordship. So, Lordship, similarly situated persons has been appointed on regular basis, whereas I have been denied, Your Lordship. Now, Your Lordship, the ground yes, Your
See,
Lordship.
that earlier notification
Yes, Your Lordship.
is not a government notification. Actually,
Lordship.
it's issued for education itself.
Yes, the
Education
petitioners.
Department.
Yes, Your Lordship. The petitioners were appointed in the Education Department, Your Lordship. And all the grateful appointments were given to landowners, Lordship. That was the norm, Your Lordship. Now, in their affidavit, they are saying that as per 2018, I am not eligible, Your Lordship. But I'm saying that that 2018 will not apply to me. And even the impugn order, Your Lordship, it doesn't mention anything about the memorandum, Your Lordship. And Your Lordship is aware, Your Lordship, a validity of an order has to be judged by the contents of the order, Your Lordship. It cannot be supplemented by fresh reasons in the affidavit, Your Lordship. Okay, I have prepared a list of authorities on the principle of, Your Lordship, that an order cannot be supplemented by fresh grounds in government affidavit, Your Lordship. If I may able to read, Your Lordship, I've just called out the principle, Your Lordship, in the paragraph, Your Lordship. One, Your Lordship, 1978, one SSC 405, Mohinder Singh Gill versus, and another versus the Chief Election Commission, New Delhi, and others, paragraph 8, Your Lordship. The validity of an order must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court, on account of a challenge, gets validated by additional grounds later brought out. Two, it is also on the same principle, Your Lordship. An order passed by the statutory authority must be judged on the basis of the contents thereof and not as explained in affidavit. Three, the validity of an order impugned has to be tested on the basis of reasoning contained therein, and that the authorities are not supposed to supplement the same by means of extraneous material or affidavit before the courts. So, Lordship, impugned order does not mention anything about the 2018 memorandum, Your Lordship. It only says that since my appointment was on contingency basis and other similar other well owners were on sanction posts, that's why my prayer could not be considered. Whereas, Lordship, as per the policy of the department at that time for landowners, I am eligible, Your Lordship. So they ought to have appointed me in regular basis, which they have not done, Your Lordship. So aggrieved, I approached this court, and the court directed to consider representation as per the 91 policy, Your Lordship. And as per the 91 policy, I'm eligible, Your Lordship. So this impugned order has to go, Your Lordship.
Is it disputed that you are a landowner?
No, Lordship.
Not disputed.
They're only saying that my appointment was on contingency basis because of exigency and service. Lordship, they have also filed an additional affidavit, Your Lordship. The respondents, Your Lordship. In the affidavit, they are stating that the petitioners are the same from the same clan, Your Lordship.
It's 24th September 2018.
I received on 16, Your Lordship.
Your Lordship, there will be two affidavits, Your Lordship.
What is the
It will be an additional affidavit, Your Lordship.
Affidavit is this 23rd April 2025. Oh, this is the additional affidavit.
Yeah, the addition.
Yes,
She's
yes.
referring the additional.
Yes, yes, additional affidavit saying what? But that the government has already appointed 4 persons.
Yes, Your Lordship, on the basis of land ownership. That's what they're saying. But Lordship, that doesn't matter, Your Lordship. At that point of time, Your Lordship, all the grade 4 appointments were given to landowners. And it's a 300 acres of land, Your Lordship. It's a huge land, Your Lordship. There are multiple landowners, Your Lordship. And Lordship, we are not seeking for fresh appointment here, Lordship. I was already appointed back on 2007. It would be a different case if I was seeking for fresh appointment, Your Lordship. Then the 2018 memorandum will apply to me if I was seeking for fresh appointment. But I was already appointed back in 2007. And at that point of time, the policy holding the field was 91. I'm eligible, but as per that policy, Your Lordship. And even the impugned order, Your Lordship, it does not say anything about the memorandum. It just said it's contingency, Your Lordship. But it is them who has appointed me, Your Lordship. It should have been in regular basis, Your Lordship, not contingency.
Where is your appointment order?
Lordship, my appointment order is at page 16, my lord, annexure B. Torquida comes sweeper, Lordship.
But there is nothing here to show that it was land ownership basis.
Lordship, none of the appointment orders on land ownership mentions that, Your Lordship. Even in the affidavit, the annexers which they have annexed stating that other landowners were already appointed, it does not say landowner, Your Lordship. It doesn't mention the word landowner in the appointment, Your Lordship.
But, and what about recommendation by the landowners?
Recommendation, my lord. Annexure, page 19, Your Lordship. Page 19 is the recommendation by the head GB of the village, Your Lordship. And thereafter, Your Lordship, page 20 is the recommendation by the principal director of the Department of School Education. Page 20. And then thereafter, page 21 is by the principal director again, Your Lordship. This is certification of land ownership. Page 21. No, page 21 is by the additional deputy commissioner, Your Lordship, to the principal director. Page 21 is by the additional deputy commissioner, certification of land ownership.
In 21, page 21, it says sole landowner.
Lordship.
I just said it's the sole landowner.
Actually, he's one of the landowner, not the sole landowner, Your Lordship. It's a huge land, Your Lordship. It's 300 acres of land, Your Lordship.
Yes. That's all.
Yes, Your Lordship.
No, please, Your Lordship. Your Lordship, here the petitioner is praying for regularization, Your Lordship, on the basis of being a landowner. The petitioner stated that they were appointed on contingency basis, Your Lordship. However, they should have been appointed on the basis of land ownership. And they are seeking that shelter because of the order passed by the Honorable Court on 19/9/2017 in WPC 192K of 2017. On this basis, Your Lordship, they are coming before this court that they should be appointed on the basis of ownership. However, Your Lordship, before coming into this, before coming into this petition, we just have to firstly see how WPC 192K of 2017 was disposed of, Your Lordship. Your Lordship, I have clearly stated in my additional affidavit that the WPC 194 in this case was filed on 15/9/2017. Your Lordship, and by order 19/9/2017, that is 5 days after the case was filed, Your Lordship, it was disposed of. The case was not delved into the merit of the case. There was no opportunity on behalf of the government to state as to how, as to whether the petitioner are the landowners or whether they are entitled or whether like any appointment has been made on the basis of land ownership. Nothing of that sort, because
But
it was
the government has not filed an appeal.
Your Lordship, I'm coming.
Does not file an appeal, yeah.
Yes, because-
2017,
No,
we're
you-
now in 2025.
That's why, Your Lordship, let me come into that. Now, Your Lordship, what is the order, Your Lordship? Before affidavit there was no opportunity, opportunity was not afforded. It was just, I believe it was disposed on the motions in more or less in a motion state, Your Lordship, because after 5 days it was disposed of. So no affidavit has been filed by the government, Your Lordship, and straight away the court has given an observation that their representation, which was pending for disposal, the representation which was pending for disposal, be disposed of. Yes, in consonance with the scheme. Your Lordship, that's it. And therefore, Your Lordship, what we have done, we disposed of that representation, stating that we cannot consider because they were never appointed, Your Lordship, on the basis of land ownership. They were appointed. How were they appointed? They were appointed on the basis of contingencies, on the urgent basis, on an exigency, Your Lordship. I have clearly stated in my additional affidavit, as well as in the previous affidavit, Your Lordship, because initially this matter was taken up by my colleague who has already made the office, and subsequently the matter was handed over to me. And so my previous colleague has already filed an affidavit. There also it is stated that they were appointed on exigency basis. There was an upgradation of government high school to the government higher secondary school. And therefore, on the need basis, since there were no sanctioned posts, urgent basis, they were appointed on a contingency basis. However, all these facts could not be brought before this honorable court or when WPC 197 was filed, or when the matter came up on 19/9/2017. It cannot be brought up. It was not being able to brought up because it was disposed of, Your Lordship, without affording an opportunity to the government to file an affidavit to project this case. They were never appointed on the basis of land ownership. They were appointed on exigency basis because the government high school was upgraded to the government higher secondary school. And that fact could be only brought up after they challenged this representation. Now, there is no question of appeal because, Your Lordship, we say that their case cannot be considered on the basis of land ownership because they were appointed on a contingency basis without a sanctioned post. And therefore, the question of appeal does not arise, Your Lordship. If there is only an order, then okay, Your Lordship, the question of appeal will arise. If we have slept up over this order, then no. We will be stating that we have slept over the rights, but we have actually disposed the representation as directed by the court, and now they are coming before this court by this petition challenging this order, Your Lordship, this order passed by the government, Your Lordship, that this should be quashed, Your Lordship. Now, all these cases has come about because we could not able to project our case. That is the first thing. The thing is that our first prayer is that they were appointed on the contingency basis. They were never appointed on the basis of land ownership, Your Lordship. That is first thing. And Your Lordship, secondly, Your Lordship, now the petitioner, we are stating in our affidavit that as per the land being donated, Your Lordship, we have already availed for appointment. We have already granted appointment to 4 persons. And now, in view of the memorandum, Your Lordship, even if assuming, not admitting that, even as if assuming that their rights subsist, Your Lordship, their rights is exhausted because of the memorandum. Now coming to the memorandum, whether that memorandum will be, the memorandum of 2018 will be applicable to them or not. Now we will come to that, Your Lordship. The petitioner counsel is well aware as to how this 2018 memorandum come into existence, Your Lordship. How this policy come into existence, Your Lordship. Your Lordship, I was apprehensive that this might come up. However, I feel that, okay, this might not come up also. That's why I could not able to brought that out. Or otherwise, Your Lordship, there was a multi cases, Your Lordship, where the government, there was a random appointment on the basis of land ownership. And since there was no policy on the part of the government to deal with the rampant appointment done on the basis of land ownership, all the cases, that is from the year 2016, Your Lordship, all the case was kept pending unless and until a comprehensive policy was brought up by the government, Your Lordship. The case was before the division bench. The division bench directed the government to frame a policy stating that there should be a comprehensive policy as to how the grade 4 appointment should be done on the basis of land ownership, Your Lordship. And therefore, Your Lordship, all the cases which are pending from the year 2016, Your Lordship, right now, I don't have the record, but if the Lordship requires, I will submit it, Your Lordship. From the year 2016, all the cases that was being placed before the Honorable Court on the basis of land ownership, seeking appointment on the basis of land ownership, was kept on hold, was kept in abeyance, Your Lord, till this policy was brought up, Your Lordship. There was a specific direction from the division bench to the government that a policy should be framed out so that appointment should be, as to how appointment should be given to the landowners, Your Lordship. Accordingly, in the year 2016, after much deliberation on 5th March 2018, this notification was brought up. A policy was framed by the government as per the direction of the Honorable Court, and accordingly, Your Lordship, this was framed now. Now, how can the case of the petition, how did the case of the petitioner was not covered? It was disposed of had there has been an opportunity granted to the petitioner to file an affidavit, then the case would have been pending. And if it would have been pending, then it would all be kept in abeyance until this memorandum, this notification came into existence, Your Lordship. And therefore, even if they say that they were not covered by this 2018, Your Lordship, if their case were pending, because it will take some time for the government to file an affidavit. So in the meantime, we all know that there are so many cases where the government, where the people are coming before the court for appointment on the basis of land ownership. So their case would have definitely kept in abeyance until the outcome of this notification of 5th March 2018, Your Lordship. The decision of the division bench, where there was a direction from the Honorable Court, I would place it, Your Lordship, by tomorrow, Your Lordship. If this Honorable insists that that should be placed before the Honorable, then I will do that, Your Lordship. Now, Your Lordship, if you can kindly come to 5th March 2018, that is the first affidavit that has been filed, Your Lordship.
Yes.
Annexure F,
Filed
page 12.
2018.
Yes. Now, Your Lordship, if you can kindly read out this policy, Your Lordship, if you might be aware, Your Lordship.
Yes, we have gone through this many times.
Yes, Your Lordship.
Yes.
Now it is, Your Lordship, it has already said that 1A, Your Lordship, 1A.
Yes, 1A.
It is stated like this. It has been laid down by notification so and so dated 26/7/2005 that no land shall be acquired free of cost and all land shall be acquired on payment of full compensation as determined by law. No further condition for employment, service, or contractual work should be entertained. Therefore, in case any department has entered into any agreement with the landowner in deviation of the laid down policy on after 26/7/2005, such agreement will be treated as null and void. Now, Your Lordship, there's already a policy of the government in the year 1997, in the year 2005, that they will not entertain any sort of appointment in lieu of the land. It will all be by way of compensation. After 2005, and there's also notification of 1997, Your Lordship, if we can look at 2 also. It's clearly written, all cases where administrative headquarters and block headquarters were set up in various parts of the state on land donated freely by individual village or peoples of that area should not be reopened for compensation or for employment in consonance with the policy brought out by memorandum so and so dated 26/1997. Your Lordship, there's already a policy there. Now, the petitioner is saying that this 5th March 2008 cannot be retrospective. How? How it will not be retrospective? All the cases were pending, and this was to decide all the cases which were pending before the Honorable Court. It was to decide. But by bringing out this policy, this notification, was to address all the cases that was pending prior to 2018, Your Lordship. So it was retrospective, Your Lordship. It was retrospective. And as per this notification, there should be an agreement. If the land has been donated, there should be an agreement. In case if there is no monetary, there is no compensation, then there should be a written agreement between the government and the petitioner. Now, the first case when they have actually filed WPC 194, whether they have actually placed before this honorable court that there was a written agreement between the petitioner and the government, that is the first thing that we should consider. But nothing of the sort is there to consider the case of the petitioner also. Nothing of the sort. Now, the petitioner is saying that they are the sole owner of the 3 acres of land, Your Lordship. Coming back to our cases, Your Lordship. They are saying that the first petitioner, that is WPC 92, the present case that we are dealing, the petitioner here, she is saying that she is the landowner of 3 acres of land, and accordingly, the Gauhati has already given a recommendation, which has already been read out by my learned counsel, Your Lordship, at Annexure D, page 18. Being the sole landowner, Your Lordship has also correctly pointed out that one. Being the sole owner, I have the right to be regularized granting scale of pay. Your Lordship, here the petitioner is saying that she is the landowner. And now if we go to the other 2 writ petition also, here also same recommendation. Sole owner, sole owner. In the other 2 writ petition. Same land, 300 acres of land, stating that I am the sole owner. And therefore, by virtue of that, my case should be regularized, or I should have been granted scale of pay. That is the prayer. All this 3 petition, if we look into it, I will bring that thing before you, Lordship. In writ petition 92, it's Annexure D, page 18, Your Lordship. And in writ petition, WPC 93K. In 93K, it will be at page 18. Page 93 will also be page 18, and '94 will be page 19. Now, Your Lordship, all these writ petition, they have stated that this land has been donated in the year 1987. It has been donated, Your Lordship, in the year 1987. The word donation, Your Lordship, I will come to that later. It was donated in the year 1987 against 300 acres of land, and stating that they are the sole landowner, recommended by the GB, Your Lordship. Each of these cases is stating that they are the sole owner. Now, Your Lordship, as I have already stated, there is no written agreement that could not be placed on the first writ petition. We could not state it, all those sort of thing. And now we are saying that because of our inability to file, because there was no opportunity for us to project our case properly, we filed our additional affidavit stating that against this land, we have already appointed 4 persons, Your Lordship. Now, even if the petitioner says, or even if not admitting, but assuming that they are the landowner, still, their rights cannot be survived. Their rights cannot be sustained because of the reason that 4 persons has already been appointed on the basis of landownership.
Their appointment orders.
Yes, Your Lordship, in my additional affidavit, Your Lordship. And one thing I want to be very clear before this honorable court, even if an appointment is made, Your Lordship, on the basis of the land ownership, it is never on the appointment, it is never mentioned, Your Lordship. There is no mention of land ownership, Your Lordship. It is just appointed like that. It will be on the record, but
Not mentioned,
that, yes,
but the recommendation of the landowner will be there and next with the.
yes, yes.
Just 5 minutes break.
Oh, please. No, Your Lordship,
Yes.
I would also like to bring before Your Honorable
I just
Court.
show these other 4 landowners.
Okay, Your Lordship, in my additional affidavit, Your Lordship. Additional affidavit, we got it, Your Lordship.
Yes.
Page 6, 7, 8. Yes, Your Lordship, and 10, Your Lordship, since the original copy is not legible, so I have make it a typed copy, Your Lordship. Page 7 will be the typed copy.
It's Government High School, New Land.
Yes.
Page 8.
Page 7 will be the one copy, type copy, page 9 type copy, page 11 type copy, and page 13 type copy. Because Your Lordship, the original copy is not legible.
So which one, serial number? Because in some of the orders, there are multiple persons appointed. So.
Oh, yeah. It will be Your Lordship, Tokra, serial number 2. Page 13 will be, not serial number 2.
First
Oh,
come
first
to
one.
page 9.
Okay.
Serial number.
Serial number 6.
6.
Akasha.
Serial number 6. Then in page 11, no, that is single person.
11 is a single person.
Then page
And
13.
13, on page type copy 13, it will
Two,
be
serial
number 2. 2 unit.
No, Your Lordship,
Yes.
as per the policy, Your Lordship, it will be confined. Why I am saying that the right cannot be sustained because in light of this four-person being appointed, it's because the policy has already made out that the appointment on the basis of the land ownership cannot be made in perpetuity, Your Lordship. Now the question may also arise, why this four-person when it cannot be, it has all been done in the year 2009, Your Lordship. So that can also not be. Yes, because all these appointments were done in the year 2009,
2007.
yes, 7.
And I was appointed in 7, Your Lordship.
Because of this, Your Lordship, against the same land, there were so many random appointments. The family members will be continuously taking appointment on the basis of land. And because of this, Your Lordship, this policy was brought out. And therefore, there was 4-person already appointed. And so now I am coming to to my case that the petitioner, even if assuming that, even if they can establish that they are the landowner and they should be appointed, Your Lordship, they still then, it is exhausted because, Your Lordship, we have already appointed 4-person. Your Lordship, secondly, Your Lordship, I would also state that these 3 petitioner, they are from the same family, Your Lordship. How, Your Lordship? Because it is very much evident from their petition itself, Your Lordship. In 92, WPC 92. If you can kindly come to page 2, Your Lordship. Cost title. Page 2. So this petitioner is the wife of Vicky Ejimo. Okay, we'll stop from there and now come to 93, Your Lordship, 93. Again, Your Lordship, page 2, cost title.
Son.
Now, again, this petitioner is the son of Vicky Ejimo. Then on the 3rd, that is I-94. It will be at para 4A, Your Lordship, page 5. On the first petition, it was projected in the cost title, it was projected as VK, but on the amended petition, they have stated at para 4A. Para 4A, page 5. The WPC 94.
WPC 94.
Yes, please.
WPC 94 was amended.
All the 3 petitions were amended, Your Lordship. Page 5, para 4A. You got it, Lordship? Your Lordship, is written that the petitioner is originally from the outright. She is married to Vicky Ejimo of Vieto Village, Newland. She is separated from her husband in the year 1998. Her father's name is so-and-so, now deceased. Your Lordship. So this person also was the wife, divorced wife of one person called Vicky Ejimomi. So now all these 3 persons are somehow deriving their rights from the person called Vicky Ejimomi, Your Lordship. So it is apparent from the record that they all are coming from the same circle, Your Lordship. So, Your Lordship.
So same submissions in the other petitions also.
Yes, Your Lordship.
They are appointed on contingency.
Yes, they are appointed on contingent. All these 3, in fact, Your Lordship, were appointed when there was an upgradation of J. In my part, if you can kindly come to my additional. Your Lordship, affidavit. Paragraph 5 of the affidavit.
The affidavit in opposition, paragraph 5.
Your Lordship, are you referring the affidavit or the additional, Your Lordship?
This is the first affidavit.
First affidavit is written, it is written at paragraph 5, Your Lordship, as to how they were being appointed. May I read, Your Lordship?
Yes.
That with regard to the statement made in paragraph so and so, the answering deponent respectfully states that the petitioner was well aware of the policy laid down for the recruitment of employee in the Department of School Education by memorandum so and so. The government has already given appointment to 4 landowners in the Government High School Newland against existing sanctioned post of grade 4 post. However, in the year 2017, the department had upgraded Government High School Newland to Government Higher Secondary School Newland, and the upgraded GHSS has no more vacancy or sanctioned post of grade 4 post. But due to exigency of the upgraded school requirement, the department has appointed the petitioner to the post of Chikidar cum sweeper at GHSS Newland on contingency basis at the fixed pay due to non-existence of a sanctioned post. So, Your Lordship, it's very clear that they were appointed on the basis of contingency contingency basis on the requirement of exigency, because there was an upgradation of government high school to the government higher secondary school. Nothing more, nothing less than that, Your Lordship. So, Your Lordship, my submission is that, Your Lordship, if at all this petition would have contested when writ petition WPC 190 192/2017 was filed. Your Lordship, all these facts could have projected, and Your Lordship, maybe at that point of time, things could have been settled. And at all this, like there was no, all the question of written, all these things would have been made clear before Your Lordship. However, since opportunity was not granted, Your Lordship.
The petitions were disposed of on the same day.
On the same day, Your Lordship. All the 3 petitions, Your Lordship. It was more or less analogous matter, Your Lordship, so it was disposed in that light. And Your Lordship, I would like to make a reference, Your Lordship, to one judgment, Your Lordship. To one judgment, Your Lordship, passed by this honorable, by our Honorable Justice Kohima, Your Lordship. Your Lordship, here also, it's said, Your Lordship, the Chishi clan, there were 4 petitioners in the Chishi clan claiming for appointment on the basis of land ownership. Against the same plot of land, they were recommended by the GB as well as their petition, their representation was also like forwarded by the department, stating that to consider the case, they were forwarded, their representation was forwarded to the government by the department, stating that their case can be considered on the basis of land ownership. All these 4, stating that they were the sole landowner, and accordingly, the Honorable Court has also dived into the situation and has dismissed the case. And the Honorable Court in this judgment has also dived into the question of, into the word, the donation also. It is stated at paragraph, page 8, paragraph 14. So, Your Lordship, I would like to make a reliance on this judgment also, where the court has observed that the appointment cannot be made in perpetuity. Here also same. There was an appointment. We have given an appointment on the basis of land ownership. Even though there was no agreement, at least the government was gracious in this case to appoint one person. And therefore, by virtue of that, the question of appointment on perpetuity does not arise.
For these cases, agreement is there.
No, that
agreement.
There is no agreement. Your Lordship, and therefore I would like to make a reliance on this judgment, Your Lordship.
Vera, you were saying?
Paragraph 5, page 8, Your Lordship. Your Lordship, I have actually submitted. It's a ditto copy, Your Lordship. There were four the four-person came before the Honorable Court seeking appointment on the basis of land ownership on the same lane. The cases was also forwarded by the department, but there was already, the appointment was already given by the department, and therefore, on the ground of perpetuity, the court dismissed the case. Here, the case of the petitioner is also being donated, the land has also been donated, Your Lordship, in the year 1987. So, Your Lordship, by virtue of this, no agreement, and since the petitioner, since the government has already given appointment to 4 landowners, and therefore, Your Lordship, the case of the petitioner cannot be considered and it should be dismissed, Your Lordship. Lordship, my learned friend is stating that they were not given the opportunity when the earlier case was filed. Lordship, they were at liberty to file an appeal, Your Lordship, and bring all these grounds, Your Lordship.
It doesn't matter now because
And
the
Lordship,
representation was disposed of.
yes, Your Lordship.
Yes.
But since it was her submission, that's why I'm saying, Your Lordship, they are saying they were not given opportunity. But if that was the case, they could have filed the appeal, Your Lordship. Even otherwise, Your Lordship, the order was passed, the impugn order, Your Lordship, 17 February, Your Lordship.
Dispose the representation.
Yes, Your Lordship, the order, Your Lordship. And the reason given is that since I was on contingency, Your Lordship, and the other landowners were on sanction posts, that's why my case would not be considered, Your Lordship. Now, Lordship, my case is that regardless of how many landowners were appointed, I'm not seeking, my case will not, the judgment which my learned friends relied on, it won't cover me, Your Lordship. I'm reiterating again, Your Lordship, this is not a prayer for fresh appointment, Your Lordship. That part is already gone. I have already been appointed. And Your Lordship, the only way I'm entitled to be appointed in grade 4 post is because I was a landowner. Otherwise, I would have been appointed in the first place, Your Lordship. This is my case, Your Lordship. Back in 2007, I was already appointed. Now, whether there is an agreement or not, this does not cover me because 2018 does not cover me. I was appointed in 2007 when as per the 91 momentum was holding the field in the education department of land owners, Your Lordship.
2018 is
Now-
a comprehensive policy which covers all landowners.
Yes, Your Lordship. So if that is the case, Lordship, more than one landowners were appointed. If perpetuity was the case, more than one landowners.
Yeah.
Yes, Your Lordship. Even I was already appointed, Your Lordship. I'm also already appointed. I'm not seeking for fresh appointment on the basis of land ownership, Your Lordship. I'm already appointed, Your Lordship.
Your Lordship,
In 2007, Your Lordship. And those people, some of them are 2009, Your Lordship. Those were also appointed on, some were appointed on contingency, some were appointed on temporary. Subsequently, they were regularized, Your Lordship. And those are all land owners, Your Lordship. So, Lordship, even the impugn order does not say anything, Your Lordship, regarding the memorandum and everything, Your Lordship. So, like the judgment which I relied upon, the validity of an order has to be judged by the contents of the order, Lordship. It cannot be supplemented by fresh reasons and fresh affidavit. In 2018 notification, agreement on what, these are all fresh reasons, Your Lordship. Nothing has been said in the impugn order, Your Lordship. Impugn order only says that since I was appointed on contingency and those were appointed on sanction posts. So my prayer is that as soon as sanction post arises, they should have accommodated me, Your Lordship. They did not do so, whereas others, they've accommodated them. Even this violation of principle of natural justice, Your Lordship. Similarly situated persons, they have subsequently appointed them on regular basis. My case was left out, Your Lordship. The question of perpetuity, everything regarding 2018 will not come to me because I was already appointed, Your Lordship. It was the state government who has appointed me, Your Lordship. And I'm reiterating again, Your Lordship, the only way I'm eligible to be appointed on grade 4 post was because I was the landowner. Otherwise, I would not have been appointed, Your Lordship, in the first place.
They're saying it, 3 to 4 persons were already appointed, but it was since it was in 2009. 2018 will not apply. My case is also the same, even 2007 appointment, Your Lordship. 2018 will not apply to me also, Your Lordship. You gave me, right? So Lordship, impugn order says that no sanction post. So if vacancy arises, I should be accommodated. And also, Your Lordship, my prayer is also for scale of pay, Your Lordship. My other prayer is also scale of pay, Lordship. So this.
For scale of pay, I
Yeah,
think that memorandum
yeah,
of
that's-
March 5th.
Yes, that will apply to me. So in terms of this memorandum, my prayer for scale of pay may be considered, Your Lordship.
Yeah, as far as the scale of pay is concerned, Your Lordship, that's,
Yes.
yes, Your
Because
Lordship.
that,
that's
for
a-
everybody. it
already,
be
yes.
considered.
But as far as the,
Regarding the
land ownership, Your Lordship, no, Your Lordship. Because now the banning on the letter that the government has disposed, stating that they were not being treated equally. They were appointed on a contingency basis without a sanction post. How this letter came about? Because there was a direction disposed of the representation. In light of that representation, it's very implied, Your Lordship. They're appointed on contingency without a sanction post, and therefore they cannot be equally be treated at par with the appointment being made on the basis of land ownership. They were never appointed on the land ownership in the first place. If at all they have been appointed, and if their representation, there was a direction by the Honorable Court for disposal of the representation, the government would have definitely regularized them. If at all, at the first instance, their appointment was done, their contingency was done on the basis of land ownership, that would have done. But it is not so. That's why it has come before your Lordship. No, Your Lordship, if Your Lordship wants a division bench, then I can
Lordship,
submit.
one more point, that sole owner, that words. Even all the landowners who were appointed, same thing, Your Lordship. The ADC, in all the landowner cases at that point of time, sole landowner, that was the norm, Your Lordship. So that cannot be the case to deprive me, Your Lordship. Yes, Your Lordship.
If it's, and usually land ownership, there is family, like two families donated or 3 families donated, like that. So all these appear to be from one family.
I agree, Your
There
Lordship.
is no specific.
I agree, Your Lordship. They are from the same clan, Your Lordship. However, Your Lordship.
Father's name,
Lordship.
same.
But Lordship.
Name, same.
What I'm saying is that 2018, if I was praying for fresh appointment, then 2018 will come. That perpetuity issue will come.
No.
But I was already appointed, like the other landowners, Your Lordship.
See, all 3 of them appointed,
Lordship.
claim me, same claim,
Yes, Your
and
Lordship.
from same family.
Yes, Your Lordship. I leave it to Your Lordship. Much obliged.
Dispose, chamber dispose. Yeah, pass order.
Much obliged.
Reserve.
Not reserve, return in the chamber.
For hearing, partner, item number 26.
The government and get against. In the meantime, you can submit, Mr. Joshua.
Your Lordship, the first reply to my learned friend for the petitioner. May I take your Lordship to the page under the paragraph 2 of the writ petition. Paragraph 2 of the writ petition.
Why respondent filed?
Yes, Your Lordship.
Paragraph 2.
Yes, Your Lordship. A specific claim has been made that the petitioner is the landowner of the EE office. May I read, Your Lordship? The petitioner is an indigenous inhabitant of Nagaland belonging to Siminaga tribe. The petitioner is the son of Sri Vitoi Chopi, one of the landowner of the existing office of the executive engineer, hereafter referred to as EE for brevity's sake. So, Your Lordship, that claim was specifically made. Then, Your Lordship may kindly turn to page 19, annexure D. That is the application submitted by the petitioner. May I read, Your Lordship? The paragraph 2 of the application, that I, as a landowner of EEPWD R&B office Atoize, has not availed any privilege, either an appointment or any contract works. So, my lord, since the specific claim was made that the land where the EE office is constructed belonged to their family, that is the reason why before I entered appearance before the Zone Court, a direction was already issued by the Zone Court to conduct a verification. Verification result has specifically come clear that they do not own the EE office. Then, Your Lordship, the government advocate will come and give the information. However, as far as the information is concerned, I have also confirmed that the vacancy is actually in the EE office. Your Lordship may kindly turn to page 36, annexure G of my affidavit in opposition.
Next year.
G, page 36. This is an application submitted by the family of the petitioners. May I read, Your Lordship? To the Executive Engineer R&B PWD Department, Atoize Division, subject application for the post of Chokidar and Sweeper in SDR and BPW Office, Atoize Subdivision, after against the retirement of Sri so-and-so Chokidar and Srimati so-and-so Sweeper. With utmost respect and humble submission, we the landowners beg to state a few lines for favor of your kind consideration and necessary action, please. That, sir, we have allotted a plot of land to the department free of cost and verbally agreed in principle for appointment of grade 4 staff to the owners by the department. So far, even after lapse of 33 years, not a single staff has been appointed for nor compensated as agreed. Therefore, we request your esteemed department either to appoint Hinoto X Chokidar to Bokatoli, that is the daughter-in-law that the petitioners council was submitting the other day. Bokatoli Sweeper against the vacancy created or to compensate whichever at the earliest as not to create hurdles. My lord will kindly take note that both of them are appointed against the claim of land ownership and not as submitted by the petitioner the other day. So Bokatoli may not be the landowner and she may just be a daughter-in-law, but on the recommendation of the family to be appointed on the basis of land ownership, both of them are already appointed. Then, Your Lordship, Your Lordship may kindly come to page 47 of my affidavit in opposition, Annexure M. So the landowners, no objection certificate. They undersigned on behalf of IM Iklan, the sole landowners of Executive Engineer PWR and Atoizu Division, Office Atoizu, have no objection against Sri Otoka Aye, a permanent citizen of Atoizu town who was appointed as MTS at Executive Engineer so-and-so. So he also, whether he is the actual landowner or not, in the same parity with Bokatuli, he is also recommended by the landowners to be appointed. Now here, the third point which I'd like to press before your Lordship is, shall we go to the prayer of the petitioner in the writ petition, Your Honor, or your Lordship?
Yes, the petition.
Yes, your Lordship, the writ petition. This is the prayer, page 8, caution set aside. Impugned appointment order dated 13 January 2023, that is the respondent number 5's appointment. Appointing the respondent number 5 as peon at the office of the Executive Engineer, PW R&B Atoizu through backdoor. So that is the only prayer, your Lordship. Here, since the petitioner, they are not the family of the petitioner are not the owner of the office of the Executive Engineer. On the claim of land ownership, the petition filed in the first place had no locus standi. So locus should have been the first issue to be decided. Your Lordship, after the verification process was conducted and it was found that he is not a landowner and the vacancy is in the office of the Executive Engineer, instead of going into any other points, Your Lordship, the locus standi has to be first decided. And if the locus standi issue is to be decided, the writ petition itself was misleading in the first place. So, my Lord, having failed to establish the locus standi, whether by filing a affidavit in reply or any form of affidavit, can it change the structure and the nature of the petition? The law is settled in that aspect, Your Lordship. So, my Lord, on these limited points, the petition itself is not maintainable. It is to be dismissed. At a later stage, the petition cannot be improved when the petitioner had no locus standi to approach this Honorable Court in the first place. I may be allowed to rely on the decision of this Honorable Court. 2005, 4 GLT 567. Your Lordship, I'm relying on para 18. May I read, Your Lordship? Paragraph 18 is at page 577. Paragraph 18, Your Lordship, only a few sentences are actually relevant. If I may request Your Lordship to turn to page 578. Then counting from the bottom.
578 or 589?
577 is the paragraph 18. And the relevant portion, Your Lordship.
5 for GLT 567.
Yes, Your Lordship. Paragraph 18 is at page 577.
Bottom, the bottom.
From the bottom, Your Lordship, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18th. The 18th line counting from the bottom. The said ground, as my Lord said. The language starts with the said ground. The said ground having not been pleaded in the writ petition cannot be allowed to be taken during argument. So, Your Lordship, when the prayer itself is on the wrong premise of asking for appointment in the office of the EE, to now turn around by way of filing affidavit to ask for other relief, Your Lordship, that is impermissible in law. That is my humble submission, Your Lordship. And my Lord, on the basis of land ownership, as we have seen from the document, that is the report of the ADC Atu Izzah. May I take Your Lordship there, or it won't be necessary because my Lord has read the other day?
For this is the report.
Yes, Your Lordship. So, Your Lordship, out of the 3 persons who apparently donated the land together, similar situations have arisen in the other writ petitions I have pressed before the Honorable Court and also has failed. Because in Poboto, my grandfathers, there are 2 cousin brothers and 4 brothers. Since the property was not divided, they donated the land where the ADC office Poboto was established. 3 brothers, now I'm in the 3rd generation. 3 brothers, they got 1 appointment each. But the 4th brother also, they wanted to claim 1 more appointment. But since 2 cousin brothers have already been appointed, this Honorable Court at paragraph 11, Your Lordship. May I read, my Lord? This court, having given an anxious consideration to the notification dated 5/3/2018, and further taking into account that the brother of the petitioner as well as his cousin brother has been duly appointed in the said office of the additional deputy commissioner, wherein the building stands on land ownership basis, is of the opinion that the petitioner has no right to claim appointment as landowner basis, more particularly in view of clause 3C of the notification dated 5/3/2018. So, since they have already claimed 2 appointments, that also on the claim of land ownership on the other land, Your Lordship, the present vacancy is not even pertaining to the other land. In this writ petition, which I failed to succeed before this Honorable Court, there were 2 offices, election office and ADC office, but it was within the undivided land. So this Honorable Court, after hearing the petition, whether the appointment was to a different office or not, it was within the same undivided land which was donated to the government. So, from the petitioner's point of view in the petition, the order that I have served to Your Lordship, sadly, the petitioner failed to succeed. And similarly, in this case also, since they have already received 2 appointments, and the appointment of Bokatuli, which was claimed to be not on the basis of land ownership, the documents itself annexed before this Honorable Court in the form of affidavit.
Recommendation.
Yes, Your Lordship, of the land ownership that she was appointed. And the respondent number 5, I was also recommended by the landowners for appointment. So the writ petition will not succeed and it deserves to be dismissed. That is my humble submission, Your Lordship.
Please, Lordship. Yes. Lordship, yes, the payment respondent number 5 was under the office of executive engineer PWD. Lordship.
And not in the subdivision.
Lordship.
Yes.
May I please, my lord. Lordship, the executive engineer, Lordship will see from the records that there are now this is they are trying to project this as executive engineer office, Lordship. But the learned council is submitting, they are trying to, there is witness And if it is not in the subdivisional office, my lord will kindly come to my paragraph in my writ petition. Paragraph 2 and paragraph. They are trying to mislead this honorable court, lordship. If it is not in the subdivisional office, why should I apply? It is in the subdivisional office. And Aya Miklan has already claimed 3 appointments in executive engineer office, lordship. They have already got 3. And this, he is not a landowner, but because he happens to be from Aya Miklan, this is the 4th one they are claiming. Lordship, here the differences is, I am the landowner, whereas it is admitted fact by both the parties that the respondent number 5 is not a landowner. But just because he happens to be from Aya Miklan, just because somebody happens to be from Jimo Miklan, I cannot give, and the respondent number 5 is from Vekoho New Village. I am from Vekoho Old, and subdivisional office belongs to Vekoho Old Village, lordship. The respondent number 5 is from Vekoho New, Vekoho Old and Vekoho New. And it is an admitted fact before, even in their own affidavit, that he is not a landowner. Here we are on the issue of land ownership, lordship. And when
there are 2 things against you. Number 1 is that nowhere in your pleadings have you stated that it is the subdivisional office against which you're claiming. It's
lordship,
EE office, EE office.
no, lordship.
Then number 2 is that already 2 persons are appointed from your family.
Bokatoli, lordship, I have already stated that that was in 2018. That which the Learned Council readout was from 2018. And they did not consider. Lordship, this is in the Bokatoli's application, it is very clear. My lord, if my lord will kindly go through it, or my lord will kindly come to paragraph 2 of my writ petition.
One of the landowners of the existing office of executive engineer.
No, lordship, wait, till the last. As I have already clarified the other day, executive engineer amounts to general. Lordship, it is very clear on the face of record. Lordship will kindly let me read out paragraph 2. That the petitioner is an indigenous inhabitant of Nagaland belonging to Siminaga tribe. The petitioner is the son of Sri Vitoi Chopi, one of the landowner of the existing office of the executive engineer, here referred to as EE for brevity's sake, PWD, R&B Division Zeneboto. Way back in the year 1984, by oral agreement, as practiced in those days, let his sons from Chopi clan donated their plot of land without cost to establish the office of EE Atuiz in consideration of grade 4 appointments. However, whenever vacancy arises, the respondent appoint others through political backing, and the clan's elder submitted complaint letter dated 6/7/1986 to the chief engineer PWD, hereafter referred to as respondent number 4 for brevity's sake. Whereof let Nitovi GB Vekoho All Village. Here, my lord will kindly appreciate that we are from Vekoho All Village, the owner of subdivisional office, and executive engineer is Ayami Clan's office. Whereof let Nitovi GB Vekoho Old, the elder brother of the petitioner's father, is shown at serial number 3 as one of the signatories. In this regard, a verification by the concerned authority, the head DB, Office of the Extra Assistant Commissioner, Authorities issued a certificate dated 10/11/2003, certifying that Sri Nitovi Chopi and Hovishe Chopi clan are the absolute landowners of the subdivisional officer PWD R&B compound at Authorities. There is no confusion here, lordship. As I have stated the other day, EEPWD office belongs to Ayami clan. They have got 3. This is the 4th. But other 3 are on land owner basis. That we are not concerned, PWD R&B office, Lordship. Here, as I have already stated, and in all the documents, it is shown apparently, Lordship, that IAME are the EE Executive Engineer Office landowners, and we are the subdivisional office. As I have already stated, there are about nearly 2 kilometers between the 2 establishment, Lordship. It's not even together. So there is no confusion at all. On that day when it was brought before the additional deputy commissioner, that meeting, that verification, it is also clear both that they are executive engineer office and I am from subdivisional office. My lord will also appreciate that I have already, my lord will kindly come to my counter affidavit. The last counter affidavit. Which para? Para 3. Yes, my case rests on this. And Lordship, also I would just apprise my Lordship, just as a refreshment of memory. Lordship, even in the recent, precedent case also, here also there is no question of in any appointment, if I approach this court with this, I will not be considered as a landowner. Page 10. No matter what the other party says, Lordship, document speaks, and this is in 2022. Plea for the post of sweeper in SDOP, WDR, and BR2Z division. Madam, with reference to the subject cited above, I have the honor to request your kind esteemed authority to consider my few words for favor of your consideration, please. That, Madam, there are 3 blocks under executive engineer at Atoiz division. 1, Atoiz, Suruhuto, Askuto. They are subdivisions, Lordship. And I am applying an application for the above said post. As the post happens to be in my place at Atoiz, as such, I will be sincere in my duties if appointed to the said post. Your act of kindness shall be highly appreciated. Lordship, in all human probability, any appointment for land ownership is pleaded on the subject, where plea for the post of sweeper and as Atoiz on land owner basis. But here, there is no land ownership. Any appointment on land ownership goes by the application. There is no mention, and if in other cases, I have seen that since there was no plea in the heading that I am applying for the land ownership, that is, I did not bring today, but the application speaks. And when there is no question of, I cannot take this application and come before this honorable court pleading for land ownership appointment. That is one aspect. And also, the appointment order speaks for itself, Lordship. No matter what the other party submits before this honorable court, we go by record, Lordship. So I have read that other day also, page 1011, Lordship. The appointment is very clear. Consequent upon the approval of the government by the number so and so, government approval 10/1/2023, Srimati Bokatoli Simi, age 31 years, date of birth 10/6/1991, education qualification, class 10 passed, daughter of Sri Nikhavi Simi of Rotomi village. Lordship, Rotomi village is of course under Atoize, but not Vekho all. Vekho all is the land owner of subdivisional office. Is hereby daughter of Sri Nikhavi Simi of Rotomi village, Zinhebodo district. Nagaland is hereby appointed as painter helper under the executive engineer PWD RNB Atoize division. Atoize vice Sri Mghali painter helper Pims code so and so promoted to water work filter grade 2 with effect from 2022 in the pay level of so and so. Now, Lordship, this is very clear that in all the appointments, even this will substantiate, Lordship.
But it is your family itself who has recommended your case.
It's not, it was in 2091, 2018, Lordship. No, I leave it to your Lordship. Judicious mind, I don't want to but Lordship will
Where
kindly
was
see
that
and
document? Which document was that where the landowners had recommended this Bukatoli?
Your Lordship, it is in my affidavit at annexure G, page 36.
See, this Rubishi Chopi, Hoktoi Chopi, Hokato Chopi, these are all your family members, isn't it? The landowners.
these are Chopik land where three, in the map where the three were divided. Map is also there submitted by the land record survey. Land record survey has. Lordship will kindly come to the DCs.
Your Lordship can see my annexure K also, at page 42 also.
IME clan has already got.
We are in the IME clan, we are five landowners.
That's why.
If we have to go by number, then three, then two more still remains. If we have to go by this same
They have got
same
three.
method.
That whether further appointment will be made or
Here,
not, that I'm not concerned.
According to the village council, the landowner of SDO office is Intovi and Hovshe.
But of course, in the map, in the report of the ADC, SDO, there are three.
Yes,
Okay.
Lordship. And this is,
However, if we have to go by the same method, IME are five.
no, that is another thing. We are not
And
disputing before the son of
the
the court.
document which my learned friend was referring to, if you see the office noting, the forwarding, the earlier application is, her earlier application has also been forwarded, so it was considered together, the office noting.
And on the question of locus standi, actually, who is he?
No, Your Lordship, as lawyers, I will apprise this on court very fairly. When you cannot establish that you are a landowner of that particular place, the question of locus standi comes, Your Lordship. It is not
This
for the
is-
sake of argument, it's a settled position of law.
Lordship, this is between a village and they are trying to
And Your Lordship,
confuse.
my sincere apologies, Your Lordship, for interfering with my learned, yes. Yes.
To be fair, they have also stated that
Yes.
the landowners of the subdivision.
Yes, that's it. Not only that, all the other
Now,
documents.
Your Lordship, here, the fact is, the ground reality, I was expecting the learned government council to submit this because I believe the petitioner's party also, they know, we know. In fact, the SDO office is not even functioning.
No, only
The
just,
SDO office is not functioning, that's a fact, the ground reality. And it is for the government council to fairly apprise this on the court that the office is not even functioning, but in the office of the executive engineer, they have been given two posts.
no,
Now, Your Lordship,
My
that
lord.
is a ground reality.
my lord.
My
Even
lord,
I was informed of that. Now what has happened is SDO
Respectfully,
office.
this writ petition is already a lost cause.
Lordship, what I have, my information is that SDO office is in a deplorable stage. That's why for the time being, for repairing of the SDO sub-divisional office, it has been temporarily shifted to now, only now. Otherwise, my lord will kindly see these two Hokivi and the other one, Tosheli, both of them. Hokivi is the one who spion post, not we are disputing. So Hokivi was first appointed in the subdivisional officer, and it is known to the public that whenever all transferred and subdivisional officers under that establishment, Hokivi was the peon. And just in 2022, he was transferred to Daftri. So also, there is another LDA lady who, when she was appointed after Hokivi, he was serving as peon and these things are placed before the honorable court. I myself had submitted. So under such circumstances, and lordship will also can see other documents. Or in all the documents, it is recommended as subdivisional office. And as I have, the other day I have appraised my lordship, engineer office is in general term, lordship, that is used. Even the appointment, even in the, but here the question is, two clan are the separate land owners of two establishment. That is the question here, lordship.
Okay, dispose it.
One clarification, your lordship, not against any argument, but at paragraph 2, I thought of the writ petition at paragraph 2. The simple claim is just the one of the landowners of the
Of course.
executive engineer's office, where the executive engineer's office is constructed. I did not see as due. That is why I was relying on that, your lordship.
Towards the bottom of this para itself,
Ah.
stated that they are the absolute landowners of the
Yes,
subdivision
your lordship.
office.
Yes, your lordship.
Even in other paragraph also I have mentioned, lordship. 7 also. It is very clear, lordship. I never claim under the, and it is I am his land. Why should I claim for over the land, lordship? That is my humble submission before this honorable court.
Maybe we will resume at 2. Any more?
Your lordship, the order will be reserved.
Yes, not
Oh.
reserve, pass it
My lord.
during the course of the day.
Your lordship. Lordship.
So far, item number 30 is concerned, my lord. I'm from the Gauhati, my lord. Just Gauhati, my lord, I'm not feeling good, my lord. Just I have medicine. Can it be at first item as hearing item, my lord? 30 at 2, my lord.
30.
Yes.
What side is there?
Yes, my lord. I will inform, my lord. He's here, very much available. Deep, lord. You can take it.
Yes. Secretary kanang provision. Secretary address provision.
Next to makan ubo.
Next to tahan upgrade mangin wishes so to be ready. You do not object. Yeah.
First day. Petition. Working. Now,
I pray that this matter come up on next Tuesday, 17th of June,
Item
29.
29,
29.
item 21, due to paucity of time, fix the matter on 20,
No.
17.
17th of June.
17.
Would your lordship be pleased to fix those matters as first item in the hearing is the parties are declared by senior counsels. It may not take much time also. We'll be much obliged.
Okay.
That's
That's
first
item.
item. I'm deeply
Item
obliged.
20.
For hearing, item number 30.
May I please your lordship? My lord. My lord, the matter pertains to my lord, the premature retirement, my lord. And the most, my lord, as per the date of joining the petition for the corporation, my lord, my date of birth was 24 July 1968. So as per 60 years, I completed.
Site.
The list.
Yes.
My lord, before starting my submission, my lord, for ready reference of this honorable court, my lord, written argument with citation and list of books for lordship convenience, I may be allowed funds, my lord. Before taking to this, my lord, original writ petition list of dates may be taken up first. Written argument, I will take your lordship letter. And no, my lord.
Yes.
My lord, written argument, lordship is here, my lord.
Yes.
Listen, this list of them, the written argument, that synopsis I'll read. Written argument. So that lordship would aware the brief fact of the case.
Yes.
The brief facts of the present case is that the petitioner was initially appointed in the post of Safaiwala by office order dated 38/1988 in the Food Corporation of India, Dimapur, Nagaland, that is annexure 3, page 31 to 32. In view of the interview proceeding dated 20/10/1987, that is annexure D, affidavit in opposition, page 18. And after due verification of his documents, thereafter he was promoted to the post of Jamadar and was serving as Jamadar till his premature retirement on 31st July 2021. That his date of birth as per the official records is 24 July 1968. And as such, his date of superannuation falls on 31st July 2028. But the other surprise and astonishment of the petitioner, the respondent number 3 was arbitrarily and whimsically by his impugn order declared 2/8/2021, this is annexure for the writ petition, my lord, asked the petitioner to go on retirement on the superannuation with effect from the 30th July 2021 in total violation of the norms and guidelines, whereas the actual date of superannuation fall on 31st July 2028. As such, the petition deprived of 7 years of his service period for irregularities and lapses on the part of the respondent authorities. Next, my lord. Before taking to the next page, my lord, can you have a look my list of dates, original writ petition that. My lord, in my these notes, my lord, one annexures I have mentioned is the 2010-1987 annexure D, right, my lord?
Annexure?
Yeah, in my written arguments, just I
Yes,
read, my lord.
annexure D.
Yes, 2010-1987 annexure D, my lord. Yes, my lord.
Yes.
Yes, my lord, this document is very much available. The affidavit opposition file accept. From that, after showing this document, I will take chronologically all the facts. Kindly, my lord, of affidavit opposition
the
file.
affidavit
Yes,
opposition.
by the respondents, my lord. My whole case starts from this and documents, my lord. Page number 18, my lord, annexure D. Page 18, my lord. Kindly mark it.
Yes, what does it say?
It is 2010-1987. Yes. I'll have to read this order. This is, my lord, interview proceeding. This is the first entry. The order to regularize the service of casual employee interview
slash test of Sri Deepak Sarkar, this is the present petitioner, my lord. Sweeper water carrier recently working under district officer FCA Dimapur was held. The following committee of the officers in regional office Shillong on 2010-1987 under chairmanship of senior regional manager, my lord. He's the vetting authority, my lord. Lordship will find at the bottom three officers are there, my lord. The first, my lord. His date of birth is written, my lord, 26/2/1960/24/7/60. Two different dates of births as per employment card. Number 2, my lord. The difference in date of birth 2, overwritten in the certificate at the time of entry, he was under grade. Number 2, my lord. He was produced a copy of the certificate stating that he was read up to class 9. Number 3, my lord. He is the FCA service on casual sweeper water carrier with effect from 4/4/1978. Since then, he is the continuing in the post of casual sweeper water carrier. Number 4, he was appointed by Swencho. Skip to directly 7, my lord. 7. Since he is a casual employee, the question of examining ACRs does not arise. Number 8, my lord, this is most vital. As per the FCA staff regulation 1971, the prescribed qualification, the sweeper in the scale of pay Swencho and should be, my lord, should be able to read and write in any language with the age limit of 25 years. A person is eligible, competent who apply for this post to appoint 44. Age limit is the 25. This clause might kindly be marked, my lord. It will come later again, my lord. 8. Number 9, my lord. That means age limit is 25, my lord. Yes, 9, my lord. All the above particulars are to be examined by the whom, my lord, by administration section to examine suitably. That means, my lord, whatever the anomalies it is there in the testimonial record certificate, this administrative section will examine as per the clause 9. Number 10, my lord. His up-to-date vigilance clearance is to be obtained from district official regional. That means 2 conditions imposed here. That is clause number 9 and clause number 10. The clause number, whatever date of births are 2 dates of births they have found here, you verified it, they examined by the administrative section, and vigilance clearance must. That means this interview board has passed this order when, my lord? It is 2010-1987. My lord, then, my lord, I will come later his affidavit opposition, my petition first. Now, I will again come this opposition, my lord, later. Here, my lord, in my list of dates, Annexure 1, page 23 is the offer of appointments. That is 13/7/98. Kindly have a look at page 23, my lord. There's a type copy, and the original one is, lord, you will find as 21. So I typed it. It is not so legible. So it is typed. 23, my lord. This is the offer of appointments. 13/7/1988. That means, my lord, that annexure D, just we have read, my lord, 27/1987. That means, my lord, administrative section is satisfied as well as vigilance done. Thereafter, offer has been made to me to join this post. Number 1, my lord. In the FCA of India, Sri Deepak Sarkar is hereby offered the post of Safaiwala in the Food Corporation of India in the following terms and conditions. My lord, number 1, 2, 3, kindly skip, my lord. This is not important, my lord. Directly, my lord, 3 and 4. Page 25. Clause 3, my lord, in the offer of appointment, he or she should also furnish the following documents duly filed and signed at the time of joining duty. 1. 2 certificates as in Annexure 1 from gazetted officer of central state government or the category 1 officer of the Food Corporation of India or a stipendiary magistrate 1 class. Number 2, my lord, the certificate of marital status is Annexure 2. Number 3, my lord, attests copies of the documents in support of his or her educational qualification, age, and experience. Number 4, my lord, the medical certificates from civil surgeon, medical superintendent of his area, Annexure. Now, number 5, very important, my lord. That is attestation form in duplicate in Annexure 4. My lord, attestation form in duplicate Annexure 4. Kindly mark it, my lord. Number 4, my lord. He and she will not allowed to join duty till he or she produces all the above documents to entire satisfaction of management. It's a close formula. It is said, if I'm able to satisfy the corporation, then they will allow me to join. As part is close form. My lord, clear, my lord?
Yes.
Yes. Now, what is attestation form duplicate and extra form, my lord? Very next page, my lord. 26 and type copy. I have annexed the relevant portion at page 26A, annexure 2.
This is the attestation form.
Yes, my lord, this is annexure 4 as per the offer of appointment. Now, my lord, we'll find number 1, my name, so and so 2. Number 7, close, my lord. My date of birth, it is written, my lord, what? 24/7/1968. That means, my lord, in the annexure 4, annexure in the Roman 4, it is attestation form. My lord, in the annexure 4, my date of birth, initial date of birth is written 24 July 1968. Kindly mark it, my lord. And, my lord, very next page, page 27. I'd like to show the lordship, the original also, my lord. In page 27, bottom, my lord, though I have typed here, that is 7, date of birth, that is 24 July 1968. Got it, my lord? Yes. Then very next page, my lord, page 28. In close number 10, my lord. That is educational certificate showing places of education with yours in school and colleges since 15 years ago. That is from Vivekananda, so and so, so and so. At the time of, my lord, class 9, I passed class 9. That is, my age was in the 31st July, 80, almost 82, my lord. That is 31st July, that is last day of the year, my lord, that is 82 years. Kindly mark it, my lord. That means at the time of class 9 passed, my age was 82. Now, my lord, annexure 3, the appointment order. After, my lord, first interview board held in the 1987, directed the administration of the concern to verify all the records, police verification. Then, after satisfying all these things, they offered me an appointment, and in close form, I have been asked to fill up the annexure 4. I have filled up it, and they accordingly, that is, after satisfying all this, my lord, my date of birth 24 July 1968, then this is appointment order, my lord. 38/1988, this order pass. I'd like to read, my lord. In pursuance of this 32, my lord, annexure 3.
Page 30.
32, my lord. This is my appointment orders as Safayola. Tell him, ma'am.
Yes.
Yes. In pursuance of this office offer of appointment letter of even number dated 13/7/88, the following persons are hereby appointed as typist and Safayola. I am Safayola, not typist, my lord. In the scale of so and so, so and so, so and so, respectively, plus other alliances as admissible with effect from their date of joining as indicated below. Number 2, my lord, petitioner Deepak Sarkar. My appointment as given appointment Safayola. I joined, that is on 26/7/88. It is also marked, my lord. 26/7/88, I joined the corporation, my lord. This is, and my lord, who passed this order? The competent authority, the senior regional manager, my lord. Now, my lord, annexure 4, this is the impugn order, my lord. That means, my lord, since 1988 to 2021, all the official communication, all the government records, and, my lord, my identity card issued, medical card issued, payslip issued, and CPF document issued, my lord. That is contributory provident fund payslip also issued, my lord. In all this testimony, there is no dispute. It is clearly mentioned, clearly written. I have annexed all this, my lord, in my petition. As I reply, it is my date of birth is 24 July 1968, and my due retirement is, my lord, 31st July 2028. Kindly, my lord. That is the impugn order, my lord. Page 34. The original is page 33. It is typed at page 34. 3-line order passed, my lord. This is the impugn order, my lord. Surprisingly, my lord. Even, my lord, before going through this impugn order, I like to say, my lord, it is very important. In the service career, my lord, his lordship is very much aware that when a person is going to be retired, my lord, it is from 2 years, the service record, they get ready that this person is going to retire. For this purpose, if anomalies, if something is there, the concerned employer asks the employee, you verify all these testimonials. Since you are going to retire, so if you want to say something, you might say this. But there's absolutely silent. And, my lord, when this impugn order is issued, my lord, I'm not aware. I went to join my duty as my regular practice. Since I am very much aware, I'm going to retire on 31st July 2028. Then 7 years remain for my retirement. This impugn order surprisingly passed, my lord, by whom, my lord, kindly, that in charge general manager. My lord, I love to read the impugn order. That is on 2/8/2021. It is for quashing. I am before this court, this order, my lord. On attaining the age of superannuation, my lord, kindly mark you. On attaining of the age of superannuation, Shri Deepak Sarkar Jamadar, that means my last posting from Sapphire Jamadar, working under FCI Regional Office, Dimapur, Nagaland region, is hereby retired from the service of FCI in the afternoon, that is 30 July 2021. My lord, here very interesting, my lord. That means I retired from the institution when, my lord, as per their 30 July 2021, my lord, and this order issued on 2 days back, that is on 2nd August 2021, my lord. And the person, I'm the person who the insurance general manager, he is the not appointing authority. I will come this argument, my lord. This is not my main basic. My appointing authority is the only competent authority to issue such order, but he is not my appointing order. This is my second legs of argument. I will come later, my lord. I'm not stressing on this point right now. Now, my lord, this order. When I received this order, I'm shocked and surprised how it could be. Since my all official document for the last 33 years, my lord, not even 10 years, 15 years, 20 years, more than 33 years of rendering of service without intimation to me, without prior notice, without giving me an opportunity. Suddenly, this impugn order passed, said that on 30 July 2021, your date of retirement last date, my lord. From which document relying this order passed by this learned official, my lord. I'm saying, since the senior, so I'm using this word learned. The learned officer has used this word. Now, my lord.
You are governed by what rules?
My lord,
For
FCI. FCI, I'll come later.
Separate rules are there.
Yes. I'll come later, my lord. When I show my citations, then I will come to them. Next page, my lord. Annexure 5, this is page 35. Annexure 5, my lord. This is the identity card issued by the FCI, my lord. Kindly have a look. Since department also aware that I am going to retire by 31st July, since my date of birth 24 July 1968. Here, my lord, in my identity card, the first photograph. Her name is Deepak Sarkar. Designation Jamadar. Staff number so. Now bottom one, my lord. Bottom one, lord, you will find my Janma Tithi, that is date of birth 24 July 68. In there, this is the identity issued by the FCI. Next, my lord. Jari karne ki tarikh, tithi, that is date of issue. When this identity card issued by the authority, that is on 24/11/2020. That means 24 November 2020, authority is very much aware. What? When next one, my lord. The date of expiry of the identity card when, my lord? That is on 29/12/2025. That means still in force this identity card. It is in July 2025. And this identity card validity up to 29/12/2025. That means still, as per this identity card, still I am the MTR employee, my lord. Kindly mark it, my lord. This is next, my lord. Page 36. The page 36, my lord, is a CPF. It is a contributory provident fund. That is contributory provident fund only, my lord. In the petition, I have though enclosed 2010-11, but in reply from 2009 onwards, I have enclosed many CPF documents. Here, lord, you will find in the very first line of the CPF account, page 36, my lord, the statement of members' accounts with contributory provident fund for the year 2010-11. Now, my lord, from left, my name is Deepak Sarkar, district Dimapur, so. I joined, my lord, it is very much clear, 26 July 1988, my lord. I joined this corporation. Next, my lord, from right side. From right, my lord, from bottom. My date of birth, what is written? 24 July 1968. Lordship, got it, my lord? 24 July 1968. And very right side, my lord, the date of retirement, 31st July 2028. That is kindly be marked, my lord. Yes, that means this CPF account, my lord, it is there, my lord, that date of birth is correct. Sorry, date of year joining correct. Date of birth correct, 24th July 68. And my date of retirement also reflected the 31st July 2028. Now, my lord, page 37, next page. Another CPA for the year of 2012. It is January 2012. Lordship will find very right side, my lord. My retirement date 2012, it is 31st July 2028. That means 31st July 2028. And bottom, my lord, my date of birth returns correct. That is 24th July 1968. Kindly mark. Then page 38, my lord. This is page 38. This is a year of 2021, my lord. This is very latest one, my lord. Lordship will get surprised, my lord. This is also CPF account issued, my lord. Right side, my lord. Yes.
Also 24/7.
Yes. My lord, my retirement date, it is second, 24th July 2020. Kindly, my lord. Is 2021. No, sorry. Retirement 31st July 28. Kindly mark it, my lord. This is the last CPF account, my lord. And bottom, my lord, my date of birth, 24th July 68. Okay, my lord. And my lord, very top, and the numbering 30, very top. What is there, my lord? July 21st, the 30th July 2021. That means my retirement date they have issued in the impleadment order 30th July 21, but in the CPF account, my lord, it is 30th July 21 date of that impleadment order date issued on 30th July 21. There is written that my date of retirement is 31st July 2028. Very important document, my lord. Kindly mark it, my lord. That means 2021 July. In the official record, in the contributed provident funds record, my date of birth is written correct. This is 24th July 68, and my date of retirement it is 31st July 28. Okay, my lord? Yes. Next, my lord, Annexure 6, page 39. Page 39 and 40, my lord. 39 and 40, I have enclosed here Aadhaar card and PAN card. Why, my lord? Why I have annexed this document? This Aadhaar card and PAN card, Mayor Singh's face not issued by the competent government authority. I have to satisfy the authority by furnishing many documents regarding my identity proof, my competency. After satisfying, my lord, the Central Union of India issued this Aadhaar card. What is written in my Aadhaar card, my lord? Year of birth is 1968. Top. Got it, my lord? 1968. Yes. Now, my lord, very next page, my PAN card. My PAN card, my date of birth, 24 July 1968. That means in the official record, Aadhaar card, PAN card also, my correct date of birth is mentioned. My lord. Then what happened, my lord? Very shocking incident happened to my life, my lord. When that impleadment order issued, my lord, that impleadment order issued on 2nd August 2021, after 2 days, when my mother came to know this fact, he was struck, my lord, and died on very date. On 4th August, my mother died, my lord. When my mother came to know the premature retirement, I said, I am the only person to look after my family, my lord. My whole salary, I look after my family, my lord. When my mother got this incident that his son premature got retirement prior 7 days of his retirement, my lord, she got struck and died. This is my mother's death certificate. I enclosed here, my lord. Lordship will find my mother's date on when? 4 August 2021. And impleadment order issued on 2nd August. That is 2 days later of my impleadment order, my mother died, my lord. Next, my lord. When I received that impleadment order at page 42, Annexure 8, my lord. Date is very important here, my lord. Annexure 8, page 42, I made an RT application, my lord. To the respondent number 7. The date of RT application is very, very crucial, my lord. It is on 7th September 2021. 7. I like to read this something relevant portion of my RT. What application, what document I sought from the authority, my lord. Can you allow me to read this? First paragraph, my lord, regarding his designation, I so and so said. from third paragraph I will read. Accordingly, my lord. Accordingly, I submitted all the documents in pursuance of the instruction of the appointing authority under reference and on satisfaction of my said documents. The competent authority allowed me to join in the service of FCI, so that I joined FCI to Dimapur on 26 July 1988 and continued service in FCI form and the said that with dedication, devotion, integrity, sincerity, honesty, etc. at FCI Dimapur and FCI Road Dimapur with the utmost satisfaction of competent authority. But surprisingly, the Honorable GM in charge issued an impugn office order dated dated 2/8/21, informing my retirement on superannuation from the service of corporation on 31st July 21. Instead of my legitimate date of retirement, attaining the age of 60 years will be on 31st July 28, as per records, which is at the premature stage of my retirement. Superannuation without prior intimation of 2 years of superannuation as per the census. So I am astonished, and for the awareness and getting confirmation thereof, I am compelled to furnish the application at your end seeking following information RTA. What are the information I showed, my lord? Please provide the following. Number 1, my lord, Roman 1. Since copies of my educational qualification, age, and experience certificate. Number 2, my lord, the medical certificate issued by the concerned medical officers as Annex 3 in the appointment letter. Next, my lord, the shadow copy of the service book with effect on 26/7/88. That means, my lord, I request them, I showed, since I joined in your corporation on 26 July 88, genuinely, and I requested them to furnish me my service records. And now skip, my lord, the bottom, my lord. Whether, from here I will read, my lord, whether any committee formed by the competent appointed authority of my age-related matter and furnish the dated report thereof to the competent authority. Please provide a copy of the committee report along with the names of committee. If not committee formed, how decided my date of retirement on 31st July 21? Please clarify, also provide the service to circulate. I pose on this point below. Here, what happened? Before taking such so serious action against then one employee, Lord, whether this matter ever been placed before any committee, whether committees discuss, yes, certain anomalies we have found in this date of birth record in educational testimony, other records. So I'm placing this issue before the competent authority. We decide on this point. If the authority is not satisfied on the point, then they issue show cause to the petitioner to come and satisfy us. We have found in certain records, since your date of birth shows, as per this record, 28, 31st July, but some documents show that you are going to read at 21. To satisfy us, then this procedures follows. If then not happy, not satisfied, then next course of actions come, my lord, then show cause, then reply, then preliminary inquiry, discipline, like this manner is followed. But here, my lord, neither intimated to me, neither I am being not informed, my lord. Suddenly, surprisingly, this impugn order issued, my lord, from all these records that annexers D in the affidavit opposition, this is my interview date, my lord. Subsequently, my offer of appointment. Why they have given me a offer of appointment, my lord? So casually then not only me, in other cases also, they casually welcome the employee, we come and join. Then after few many years of doing, then no, you're going to do a surprise. No, this is not possible. My lord, date of initial appointment is very important for any government institution or any corporation, my lord. They have to satisfy us. He is eligible or competent for joining of this post or not. Since everything is done, appointing authorities, 3 members here, they have verified, checked all the records, all medical testimony, everything went there. They offered me. It is not that I am in recruitment process, then I applied for it. They offered me. Before joining up, I used to do a casual employee there. They offered me an appointment, my lord. And according they are offered, my lord, I placed my all the records, testimonial on satisfying all this in my records, Annexer 4, 24 July 2019, they have accepted this. Since for the last 33 years, they are silent. After 33 years, suddenly one get morning, my lord, this impugn order passed without prior intimation to me. This is very important. It's an absolute violation of natural justice, my lord. I realize some natural justice point, citation, my lord. Next, my lord, what? No information furnished to me, my lord. Then instead of waiting to them, my lord, page 45, annexure 9. What in their application, my lord, lordship will get surprised, my lord. They, after lodging of, RT application I made on 7/9/2021, my lord. Kindly, my lord, 7/9/2021, my lord. Yes, my lord, I will come, my lord, I will come. My lord, the affair lost more than 2 months back, that is on 6/10/2021. I will come their affair. They have enclosed it in their affidavit, my lord, opposition, my lord. They lost affair on 6 October 2021. That means they're silent. They're happy. They issued impleadment order, that order. When I raised this issue, when I saw testimonial, service record, document, education, over, then without furnishing document, surprisingly, they lost affair, my lord. What happened, my lord? I'm not a private person, my lord. I'm their employee. In any service, lordship is very much away in service law, in service process, my lord. If department is not satisfied, then some service manual, service law is there. It is to be followed. How affair comes, my lord? I will come, my lord. Then, my lord, page 45. I wrote a letter to the officers in charge, that is on 18/10/2021. Kindly provide me a copy of the affair. Even affair copy has not been furnished to me, my lord. It is the violation of section 50 and 50 of Evidence Act. When any affair laws for anything, something against any person, you have to intimate him first. This document is against you. But I have to make a request to the officers in charge. Please, one affair lost against me, you furnish me the copy of the affair, my lord. This is my application. Next, my lord. Annexure 10, page 46. This is my second RT application, my lord. Before the Central Public Information, page 46. Similar question, similar query I raised here, my lord, to furnish me a document. Next, my lord.
In pursuance of 7/9/2021.
Yes, this is first one.
Nothing was
Nothing. That is, my lord. My lord, page 46, my second RTA. Kindly have a look, my lord. The reference I have given here, my lord. My earlier RTA application 7/9/21. That is annexure 8, page 40, my lord. Kindly mark it, my lord. It is a reference I have given that first RTA I made on 7 September 2021. That is my second RTA application. That is on 3rd November 2021. Then, my lord. Annexure 11, page 50. I lost the complaint before the respondent number 7 for not furnishing of RTA information dated 26. Since my second application, they have not provided me information. But accordingly, on 26/11/21, this is my complaint, my lord. This is my complaint. This is not RTA application. This is the complaint. Next, my lord, annexure 12, page 53A. This is the refusal from their part to me, my lord, by the assistant general manager. What is written, my lord? That as sought by you through your application dated 30/11/71, not even single whispers over 7 September 21 concern, my lord. It is top informed that since the matter is under police investigation, my lord, so the information sought is hereby denied as per DCJ. So, my lord, seeking information RT is my right, my lord. Police investigation. I'm copying, I'm not seeking, praying for original. You furnish me the photocopy. It is my right as per the law. But he said that police investigation is going on. Therefore, you are not attached to it. We are not furnishing it. This is their response. Next, my lord, page 13, page 54. This is the second complaint before the respondent number 6, my lord. That is on 13 January 2022, my lord. Here reference I have given, my lord. My previous RTA application is concerned, my lord. This is my second complaint. Next, my lord, page 14. Having no RTA application, no reply file, I prefer an appeal, my lord, at page 58. That is on 28 November 2022. Before the Sarvashri Ishvardhan Kumar Sinha, the Chief Information Commissioner, my lord. It is on 28/11/2022. before the respondent number 6. Next, my lord, page 62, my last representation, page annexure 15. My last representation before the general manager, respondent number 3, this is on 12/7/2023, my lord. Since 2021, I'm pursuing the matter. 2022, I'm pursuing this matter. Nothing, not even there. Just I read one document, annexure 12. They have refused to furnish me document. This is my last request. I requested them why I have been prematurely retired, my lord. No, my lord. No information furnished. Accordingly, my lord, page 65, the last annexure of my writ petition. Kindly, my lord. This is the order passed by respondent number 5 regarding all my complaints and decision furnished here, my lord, page 67. Their decision simply they have denied, dismissed my application, my lord. That means, my lord, from when I got the copy of the retirement, my lord, I fight to get all these documents before the concerned department, concerned authority. Not even single copy they have issued to me. Ultimately, they refused, my lord. Now, my lord, my list of dates, my lord.
What ground it was rejected? This
Yes, yes. I will read. Yes, I will read. I will read.
This CIC?
Yes, I definitely read, my lord. In the light of the facts of the case and the submission made, page 67, my lord. In the light of the facts of the case and the submission made by both the parties, and the commission observes that the instant matter is a complaint filed under section so-and-so RT so-and-so, whereby the commission is only required to ascertain if the information has been denied with a malafide intention or due to unreasonable cause, which is not existing in the present instance. Furthermore, the legal position with regard to the powers of the commission under section 18 is not longer res integra, since the pronouncement of the judgment of Honorable Supreme Court Chief Information Commissioner dated so-and-so, when it was held that the section 18 and 19 serve two different purposes and one cannot be substitute or another. The commission, however, finds that the reply to the RT application has been drafted in a careless manner, since exemption can only be claimed under section so-and-so under RTHO. No such provisions of section 8H exist. The commission also cautioned Sri Mandip Gore, CPI of Percy, to ensure that the limelines stipulated under RT application 2025-25 are strictly complied, and further future filing which panel action as per. This is the observation made against their official. Ultimately, my lord, in view of the above observation, no further intervention of the commission is required in the instant complaint, which is dismissed accordingly. Nothing observed, no observation, thus simply dismissed, and certain strict observation made against some this RT officers, my lord.
Yeah.
Next, my lord, in my list of records, my lord, affidavit in opposition page may be turned up. Affidavit in opposition in my list of dates, my lord. Well, I'm sorry, my lord. Can I have a little water, my lord?
Affidavit in opposition.
Sorry. Sorry, my lord.
Yes.
I'm sorry, directly, my lord, hot water, sir. I directly. Sorry, my lord. My lord, affidavit in opposition. Filed by the respondents 1, 2, 3, 4, except 5, 6, and 7. Here, Lord Chief. In affidavit in opposition, my lord. So I have mentioned annexure C, no, annexure B first. It is already lordship has gone through. This is offer of appointment, my lord.
Now we are looking at the affidavit in opposition.
Annexure A, my lord.
Annexure
A.
A.
7/11/78, my lord.
Okay, 7/11.
This is, my lord. Earlier, my lord. Before joining my regular appointment, my lord, petitioner, very young age, my lord, used to work in the corporation as casual sweeper, my lord, not regular employee, my lord. That document they have enclosed here as annexure A, my lord. Then, my lord, annexure B. Annexure B, lordship will find.
This is that offer.
Yes, my lord. Type copy, my lord, at page 14. This document, my lord, same document, my lord, offer of appointment, it is same, my lord, as annexure 1 by writ petition. I have gone through already.
Yes.
Same document. So I skip this offer of appointment. Next, my lord, annexure C. They dispute that, my lord. For the first time, my lord, one document enclosed in their affidavit opposition, that is the certificate issued by the employment service, my lord. That's it, got it, my lord? Page 6,
Annexure C.
annexure C.
Yes.
Yes. Lordship will find my name, applicant name, this is Deepak Sarkar. My part of
Date of birth.
applicant, it is written, my lord, kindly see, my lord. 26 to 60, my lord, overwritten, marked it, my lord, 60. We have stated in our application, it's a manipulation, 60. Next, my lord. Annexure D. Though very initially, lordship, this document I have shown your lordship.
Yes.
Yes. So I don't need to waste your lordship time, my lord. These documents, my lord, I will again repeat, my lord, in the 87, before issuance of offer of appointment, this interview board I have to face. They have found to date of different anomalies on my date of births. They have instructed to the authority concerned, that is the administration section, to examine suitability, and police vigilance is there, my lord. And moreover, clause 8 is concerned that age limit up to 25 years. It is clear, my lord. Next, my lord, annexure E, 1 class 9, page 19, my lord. 1 class 9 certificate they have enclosed here. I'm very surprised, my lord. Nice, school's name is clear. My father's name is not clear. Even, my lord, if you see, my lord, dated 31/12/86, my lord, kindly mark 86. At the bottom, it's overwritten 86.
31/12/86.
86 marked it, my lord. And even, my lord, in a paragraph, in a reply, with categorically stated, I will come to reply, my lord. This document never ever been furnished or submitted by the petitioner before the authority concerned. Even from where this document they got and annexed here, I'm surprised. Next, my lord. FCI rule, annexure G, page 23. That is their rule, my lord. Yes. My lord. My lord,
Yes.
the FCI rule they have furnished, not the whole FCI rule I have here, my lord. Kindly.
This annexed here also.
It is not annexed, my lord. I'm supplying this. They have annexed it, but for your lordship, the points I will show lordship. This is regulation 1971, my lord. Lordship, I mark it, my lord, clause 5A. Clause 5A. Clause 5A, my lord.
5A.
Yeah, my lord.
Yes.
Yes. The following general conditions shall apply to all the appointments to the service of the corporation. Number A. No person shall be eligible for initial appointment unless he has attained the age of 18 years. That means if any employee to join the corporation, 18 years is the age limit. My lord?
Yes.
Yes. Number D, my lord. Roman D. No person shall be initially appointed unless he has been certified by a qualified registered medical practitioner approved by the appointing authority to be of the sound constitution of the medically fit to discharge his duties. My lord, this point can be marked, my lord. Medical document in my reply, I have enclosed, my lord, medical document. That means medical practitioner certification is very essential here, my lord. Next, my lord. Clause number 22.
Superannuation.
Yes. Superannuation and retirement. Clause 1, my lord. Every employee appointed to the service of the corporation shall retire on the afternoon of the last day of the month in which he attained the age of 60 years. Kindly, my lord. That means, my lord, joining 18 years must and retirement 60 years as per their norms, my lord. Now, my lord, clause 5. Who is the competent authority?
22 clause 5.
Yes. Clause 5.
The competent
Page 19, in our page 19. 5. The competent authority for the purpose of this regulation shall, in respect of an employee, be the authority competent to terminate the service of an employee equivalent rank under clause 1 of regulation 19. What is regulation 19? Next, regulation 19, we note. That means regulation 19, who is the competent authority? In regulation 19, clause 3, we note. In our base 16, 1.6. The competent authority for the purpose of this regulation will be an authority not lower in the rank than the appointing authority. This is important. The person who issued that impleadment order, whether he's a competent authority, it is the in charge, not the appointing authority, kindly not. Then, my lord, their document, page 30, annexure H. 1 contributory provident fund record 2003 and 4. I have enclosed in my repetition 9, 10, 11, 12 onwards, but here 2003, 2004. Why not 2002, 2022, 3? Why not 2004, 2005, 6, 7 onwards? Why only this document they have enclosed here? My lord, kindly see. Since in my repetition, my lord, lordship is since in the CPF account, my date of, my name, my date of joining, my date of birth and date of retirement is there. Lordship see this. Here lordship will find
Here it is 61.
date of birth 61 and date of retirement not there. Lord. Got it, my lord?
Yes.
Can we mark it, my lord? Next, my lord. Annexure K 30, FIR, my lord. What is actually FIR against me, my lord? Page 33. FIR when lost, my lord? I made RTI application when, my lord? 7 September 2021. Then after RTI, my lord, this FIR lost. If the language of the FIR is very important here, my lord, then I will make my submission. May I read, my lord?
Yes.
This affair, my lord, lost by one assistant general manager. Okay. The subject is what, my lord? This is important. Filing of the FIR for cheating, my lord, cheating and tampering of documents. During the course of pre-audit of service book and leave accounts of officials of the Food Corporation of India, Nagaland region, we have come across a case of tampering of date of birth of one of our staff, Sri Deepak Sarkar, ex-Zamadar, address Sencho. The date of birth of Sri Deepak Sarkar has been recorded as 24/7/61 in some official documents, while in some other official documents, the date of birth has been tempered and changed 24 July 68. Kindly, my lord, that means in the effort, they have found in some date of birth written 24 July 61. In some other place, they are saying that in 24 July 68. Kindly mark it, my lord. If the actual date of birth of the Sri Deepak Sarkar is 24/7/61, he should retire on 30 July 21. Mark it, my lord. That means as there's, if they presume that that's out of this document, they're under presumption, they're not sure that if we take the 24/7/61 document, his date of return is due on 30 July 2021. They're not sure, my lord. However, the matter of tampering of date of birth came to the knowledge of this office on 29/7/21. My lord, this is most crucial date, my lord. When it has come to their knowledge, the very first date of issuing or impleadment order. Impleadment order is, my lord, they retired me on 30 July 21, and then prior to one day only, that is 29/7/21. That's a very crucial point of my case, my lord. And you only first date of the issue, my date of retirement, it has come to their knowledge. For the last 33 years, they waited, they're sitting silent, and my lord, this fact come to their knowledge on 29 July, on 30 July, they issued that my retirement very next date, my lord. Since they are confused, my date of birth is 24/7/61 or 24/7/68. Next, my lord. Against the superannuation order dated 2/8/2021, the Deepak Sarkar has filed an RTI 7/9/21 seeking certain documents by claiming that his date of birth 24 July 68 and that he has been prematurely superannuated. This office is of the opinion that Sri Deepak Sarkar, in connivance with some of our dance staff, has tampered with the official document, changed his date of birth 24 July 61, 24/7/68. Now, Mr. Milord, my submission here in this case. When after 33 years, it has come to their knowledge on 29 July 2021 that there is a two date of births. If that be so, that stays past before 30 years. Because 1987, they strictly directed the administration authority, competent authority will verify all the records. Police verification is to be done. Then after all this satisfying, then department issued office order. This is in the service record. Why they have offered me, my lord? It is not that the surprising 24/7/61 document suddenly brought from sky. No. From which document, from which static? It is very much available with the custodian. I am the grateful employee. I am the Safaiola. My last posting is Zamadar. They are the custodian. This document for the last 33 years with them, my lord. Why do they have not addressed these issues, my lord? And surprisingly, on very first day, he got this news that my date was supposed to be census date. And 30 July to the very next day, my lord, that's my date of retirement they issued. And my lord, they have said that tampering and connivance with some other official. Where, my lord? My lord, I'm very sorry to say, my lord. Since all without proof, without examination record, without giving me an opportunity, if I fail to answer, rectify whatever the question they have raised to me, if I'm failed, if I'm not able to give proper answer to them, then the question of comes after taking other witnesses, evidences, other officers who are actually custodian of this service records. without recording their statement, without giving me an opportunity. How they can say, my lord, that it is a tempered document? And moreover, they have said that 2 dates are there. So accordingly, first date to 30. Why not? Why they have chosen 24/7/60? Why not 24 July 68? What is the material available before them? That why they have chosen that my date of birth 24 July 61, my lord? Nice, my lord. Annexure L, page 37. Very surprising, my lord. Then, having no alternative, my lord, I approached before this honorable court. During pendency of the writ petition, my lord, these officers in charge has filed the reports, my lord. The report is very essential. I have to read.
68 IO's report.
Yes, IO's report. During pendency of the matter before this honorable court, this inquiry conducted, my lord, this inquiry dated
17.
yes, my lord, that is on 17/8/2024. Yes, I like to read this report against me, my lord. Then I will come to my reply. Lordship, due permission, I like to read this report.
Yes.
May I read, my lord? That is on 17/8/2024, the police inquiry report. What inquiry they have done, what report has found by the police. I have the honor to state that on 6/10/21, a written complaint report was submitted at the East Police Station, Dimapur, by Mr. Arun Kumar Mandal, Assistant General Manager of the Food Corporation of India, stating that one of the staff, namely Deepak Sarkar, ex-Jamadar, dated date of birth has been recorded 24 July 61 in some official documents, while in some other documents, the date of birth has been tempered and changed to 24/7/68. If the actual date of birth of Deepak Sarkar, 24 July 61, he should retire on 30 July 21. Accordingly, superannuation order Deepak Sarkar was issued on 2/8/21. Against the superannuation order in 2/8/21, Deepak Sarkar has filed RT application 7/9/21, seeking certain documents by claiming that his date of birth is 24 July 68 and that he has been prematurely superannuated. The office is of the opinion that Deepak Sarkar, in connivance in some of then staffs, has tempered the official documents and changed his date of birth from so. My lord, this is important. The office of the opinion, my lord, this is opinion. This opinion part makes him mark, my lord. It is the opinion, my lord, not concrete proof. The opinion that Deepak Kumar's, the present petitioner is connivance with other stuff, has manipulated his tempered this document. Opinion, my lord. During inquiry, the complainant has been examined, my lord. This is very important. There is this observation. During inquiry, the complainant has been examined. I'm being examined, my lord. And who has stated there, saying, as stated in the affair, the complainant has been requested to submit the name and particulars with the address, if possible, contact numbers of the then employee of the office who deals with the service book of the FCI department. I am being asked, my lord, the person who actually custodian of this all service record, they sought contact numbers.
You, the complainant.
Complainant, yes, complainant, sorry, complainant. From complainant, they sought the custodian's contact numbers, my lord. This is most important, my lord. The father, Deepak Sarkar, has been requested, who has appeared at the police station and submitted his birth certificate issued by the Department of Economics and satisfied Nagaland issued on 10/9/2007 with registration number with the change essential, and stated that his date of birth 24 July 1968, my lord. My date of birth, my birth registration certificate issued on my correct date, that is on 24 July 1968. This is my case, my lord. And not 24/7/61. It is by whom, my lord, is the birth registration authority, my lord. On asking about his first earlier birth certificate, he has stated that it has been lost and so applied for a new one. On questioning him whether he has lost affair or not at this respective police station about the loss of his birth certificate for inquiry and verification in order to get new birth certificate, but he has not reported the matter at this police station. That means, I will continue, my lord. That means here, my lord, that means After 33 years of rendering of service, this question of first time raising the authorities raising this query, my lord. Now, my lord, I have visited the Economics and Statistics Department, Nagaland, to inquire about the birth certificate of Deepak Sarkar to check and ascertain the documents submitted at Economic and Statistics Department by the Deepak Sarkar while applying for the birth certificate. But the Economic and Statistics Department could not produce any record on issuance of birth certificate Deepak Sarkar, stating that no any record could be found in the office, and the report has been submitted by the Department Economics and Statistics on NHRA and closed here. During inquiry, it is found that the many of the official documents, especially in the service book of the Deepak Sarkar, overwriting is found on the date of birth and also has collected some of the relevant documents of the Deepak Sarkar from the FCI office, which is enclosed herewith. It is to be mentioned that during inquiry, collected interview proceeding of the Deepak Sarkar 1987. That means this is Annexure D, my lord. Under the committee of 3 deputy managers FCI shown Annexure D enclosed, it has been ascertained that before 26/7/88, Deepak Sarkar is working as casual employee, is not disputed, my lord. After Safayola is under age. And so remarks given by the committee in serial number so-and-so, that is 26/660 and so-and-so 24/61. The age limit for the regular job in the sweeper post is 25 years of age in mentioned in the clause 8, my lord, that is in clause 8 of the Annexure D, my lord. The upper limit is 25, it is written, my lord. And so the committee set up the 2010-1987 for the regulation of casual employee to look into consideration of the date of birth Deepak Sarkar, that is 24 July 61, who has reached the 25 years age limit, and the Deepak Sarkar as a casual worker has been regularized into the job on 26 July 88. So the date of birth 24 July 68 does not arise as per the documents, my lord. This authority is saying this, my lord. Now, the official documents of Deepak Sarkar enclosed here with shown Annexure C, the serial number 10. It is mentioned that he had studied up to class 9, left Vivekananda ME School, Assam, 31/12/1981, but it has been ascertained from the occupant of Deepak Sarkar, school living certificate, so School, Assam, which was submitted by the FCI. Deepak Sarkar during the time of his appointment in the job clearly shows that he left the Vivekananda 1975 on promotion to class 10 and not 1981 enclosed Annexure D. Further, it is to be mentioned that the documentary record is shown in Annexure B enclosed with the serial number 8. How they serial number 8 of the Annexure D interpreted this is very surprising, my lord. Come next, my lord. The age limit is 25 years of age to be appointed at a regularized in the post of sweeper in the FCI. And so if Deepak Sarkar is born on 24 July 68, he will be 21 years age during the appointment regulation 688 and will be under age and does not meet the required prescribed age limit as per the interview proceeding. If Deepak Sarkar year of birth is 61 at the time of appointment 88, he will be at the age of 27 years and is eligible for the post sweeper FCI interview proceeding norm. My lord, as per the FCI norms, FCI guideline, Annexure D, the age limit is 26, but interview said that he's eligible if age is 26, 27. How I'm eligible if I attain the age of 20? My age limit is 25 years only. If 25 years, you know, if one day even extended, I'm not eligible for. How they can make such kinds of serious statement that 26 and 27 I'm eligible? This is absolutely overlooking the norms of the FCI guidelines, my lord, Annexure D, my lord. Got it, my lord? Now, my lord, Annexure A.
They also say that if it's 68,
yes,
you will be only 21 years.
Yes, my lord. 20 will be the limit, my lord. My lord, Annexure A. The certificate issued by Brass Authority, my lord. Here, my lord, during inquiry, this document they have received from the birth registration office. What? This is to state that the birth certificate in respect of the Sri Deepak Sarkar, the bearing registration number so-and-so, certificate number so-and-so, registered and issued on 10/9/7 was issued from this office in good faith. However, it may be mentioned here that the details reflected in the birth certificate are based on information written orally given by the applicant and hence to ascertain as to whether the date of birth of the applicant is true or genuine, if not, is the possible. Moreover, the birth certificate appears to be dubious as for upon scrutiny. and perusal overwriting in the name of father of the applicant. It is not overwriting so far as my date of birth is not disputed. My father's name little different overwriting date of birth. So far as overwriting in my date of birth is not mentioned. Kindly mark it. My father name, my lord, not my date of birth. Kindly note. This is now, my lord, in response to their affidavit opposition, I file reply, my lord. My reply may be taken up now. What I responded to their affidavit. My lord, this is annexure 1, page 12, 14. This is the attestation form, though I have enclosed in my petition. Again, I'll have to draw your lordship kind attention that annexure 1 again, my lord. This form is the most vital records of without filling out these documents, this is registration form, I am not eligible to join their respective, their corporation, my lord.
Page 12.
Page 12, 7.
Same thing. That's
Same in annexure 2 in my petition, my lord. It is
7.
same date, my lord. Got it, my lord? Next, my lord. Page 16, my lord. The last page of this attestation form. My date of joining, that is bottom, my lord. On 26 July 88, when I joined their corporation, that is the date, my lord. I joined this corporation by filling up this attestation form.
Where is that? Oh, 26.
Page 16. Bottom, my lord. It is signature of the candidate Deepak Sarkar.
Yes.
Date 26 July,
26.
place Dimapur. My lord,
Yes.
that means 88, they accepted it. Now, my lord, page 70 onwards. These documents I could not enclose in my petition earlier. Now I am enclosing here, my lord, in my reply. This is my contributory provident funds records. That is 2009 and 10, my lord. Mark it, my lord. In 2009, 10, my lord, my date of birth and my name is, sorry, my date of joining and my name is there. And right side, my lord, my birth is 24 July 1968 and date of retirement 31st July 28. Yes, my lord. Page 17, my lord. Annexure 2 series.
17, 18, 19.
Yes, my lord.
All your
Most
CPF.
important, my lord. This is 18, my lord. 18, 18, my lord. 18 is a 2010-11, my lord. And 19 is a 11-12, my lord. Kali year mark, my lord. Same, my lord. Annexure 3 and Annexure 3, my lord. The lordship has seen already in my description pen cut. It is there, my lord, 24 July 68, my lord. So very next page, my lord, Annexure 4. Identity card in the petition, I have enclosed this, my lord. It is issued by the Department of Authority, my lord. My date of birth is up to my I-card is valid up to, my lord, when? 29/12/2025 in the bottom. Very bottom, my lord, in page 21. Yes, my lord. And my lord, next, my lord, this is very important now. This document, first time I have enclosed in my reply. In the reply, this document,
Payslip.
page, my lord, in page 22. 22 to 25. This is the page slip, my lord. This is the page slip. Here also you will find in very right side, my lord. The page slip, which here, with the top, my lord, it is 27 February 12. That means 2012 February. Here, my lord, my date of retirement, 31st July 2028. Yes, my lord, very right side. Retirement date then. Retirement date.
Yes,
Yes, my lord, kindly mark it, my lord. 31st July 2028. And my date of birth, 24 July 68. Yes, my lord. Then next page, my lord, it's the year of, my lord, 31st July, sorry, 2017, my lord, it is 2017, my lord. Then, my lord, page 24. That is January 2021, my lord.
Wait, this annexure 5, the dates are not clear.
Yes, my lord,
This is
my lord, date is 2017, my lord.
17.
17, it is 17, dark, it is little dark, my lord. And page 24 is clear, my lord, that is January 2021. January 2021, my lord, my retirement date, 31st July 28. And my date of birth, 24 July 68, my lord. And my last pay slip, lordship will find at page 25, annexure 5. That is, my lord, 31st July 2021. That is my date of retirement as per impugn order, 31st July 21, my lord. 31st July 21, pay slip, what written my date of retirement, my lord? 31st July 28. Why before issuance of this impugn order, why they have not verified this record? By relying which document they have issued that impugn? That is very much clear on 30 July 21. That is my last date of retirement. My date of retirement very much clear, 31 July 2028. My date of birth, 24 July 68, my lord. This is the last pay slip, my lord. This is the pay slip. This is not typed by me, my lord. This is their documents. Now, my lord, one close lordship has seen, my lord, in the for appointment, my lord, medical identity card, my lord, notice, my lord, medical identity card, educational college, I have to submit this, my lord.
Yes, yes.
Medical document, medical card, I have enclosed it. Page 26, annexure 6, my lord. Medical document, after verifying my records, date of birth, what is written, very first one, my lord, my family members, all, my one, Deepak Sarkar, date of birth, 24 July 1968. At my, this is my initial date of appointment, my lord. Date of birth, my lord, 24 July 68. It is also service record of the department authority. I have placed this document after considering all these medical documents, testimonial, they have given me an offer appointment, and subsequently I have been filling up to the annexure 4, attestation 4. I have been allowed to join on 26 July 1988. Then, my lord, the last one is, you know, simple Aadhaar card. Lordship has seen. Lordship has seen the Aadhaar card.
Yes, same thing.
Same thing, my lord. Same thing. Yes. That means, my lord, I'm going to rely some citation to support of my case, my lord. Before going to the citations, my lord,
We'll just continue. up to
yes,
further
yes, yes, my lord, yes. Great accident, great accident, which you have to really say. But surely this is saying that the accident was check My lord, before taking to your lordship and attention to the citations, my lord, I like to say sum up my submission, my lord. I'm not casual manners, not been given appointment, my lord. I have to face interview board as per interview board restrictions, guidelines relying by the FCI department. There are offer of appointment have been made, and offer of appointment also certain condition raised. I have to furnish all these things, my lord. After satisfying all these things, my lord, on 26 July 1988, they have given me an appointment, my lord. I respectfully submit before this honorable court, my lord, since 1988 to till the date of essential imprisonment order, my lord, I never faced any such situation from the department. Even during my course of the service period, for my good character, my good reputation, they issued high increment to me, my lord. This all testimonials, it is all available in their service records, my lord. I'm very surprised how they can issue such kind of imprisonment order without affording any opportunity to me, my lord. That is also, my lord, after rendering of 33 years of service. If lordship is very much aware, my lord, in the Evidence Act, now BSA has come into the place, my lord. The document relying, my lord, they have placed me premature retirement, my lord. After 33 years, the lordship know, my lord, that more than 30 years old document, there is no need to prove, lordship. BSA section 92. Kindly. Then I will take your lordship. The citations I am going to deny. BSc. No, hold it, look. Sir, please give it. Please give it. No shit. Please. Please. My lord.
BNSS.
This is BSA, my lord. Earlier it was the Evidence Act. Section 92, my lord.
Presumption.
Presumption. Then that document they have accepted, received prior to 33 years back, my lord. Now, after 33 years of rendering, my lord, they're disputing my date of birth, my lord. This section devotes the authorities to raise such kind of question to me after rendering of 33 years of service in their corporation, my lord. Is this my reward, my lord? Since for the last 33 years are rendered service, they at least, if there are some doubts, they could have raised this issue prior to that issue, that order. Well, nothing, my lord. It's a clear violation of natural justice, my lord. Now, my lord, in my written argument, my lord, that note may be taken up, my lord. Come. And even though, you know, as per the medical certificate in my reply annexure 6, my lord, my mother's date of birth is 48 and my 68. If my age is 60, they are saying that means only my mother is 12 years old to me only, as per dear, my lord. Now citations, my lord. Page 7 of my written argument, my lord. First case I'm going to rely, my lord, Shankar Lal versus Hindustan Copper Limited in address 2020-22 6th SEC 2011, paragraph 27 and 29, my lord.
Twenty-seven and 29.
Yes, my lord. Paragraph 27 and 29. It is Shankar Lal. Five citation I will rely. May I read, sir?
Yes.
Honorable Apex Court discussed. We find the action of the employer lacking in authority of law in this case on two counts. First, it fails for not adhering to the principle of natural justice, admittedly in my case also. The decision not to follow the service book record bill was taken without giving an opportunity of hearing to the appellant's, my lord. Same my case, my lord. The opportunity of hearing of the appellant also accrued because the employer, it is the FC Corporation, my lord, employer themselves had proceeded on the basis that a later date, so was the date of birth date of the appellant, and this was a long established position. Moreover, since in the own records of the employer, two dates were shown, under normal circumstances, it would have been incumbent on their part to undertake an exercise on application of mind to determine in which of these two records the mistake had crept in. That process would also have had to involve participation of the appellant, which would have been compatible with the principle of natural justice, admittedly violation of this observation made by this honorable apex. So now, my lord, para 29. The very reasoning on which an employee is not permitted to raise age correction plea at the fag end of his service to extend his tenure should also, my lord, this is very important, should also apply to the employer as well. That means if any employee, the fag end of his retirement, he is raised, no, my date of birth is this, not this. No, honorable apex court, you cannot. Same principles also apply so far as employer also, my lord. That means honorable apex court held that the very reasoning on which an employee is not permitted to raise age correction plea at the fag end of his service to extend his tenure should also apply to the employer as well. It is the employer here who had proceeded on the basis of age of the appellant reflected in a service book during the letters of the service tenure, and they ought not to be permitted to fall back on the form B, which would curtail the VRS benefit of the appellant. Here, same thing has been done to me, my lord. Very back end, two dates of, if I suppose for presumption, I'm not admitting, but some, for instance, when I'm presumption, my lord, that, okay, after 32 years of rendering of service, allowing me to continue service, suddenly you got two date of births. Then what is to be done under circumstance? Then honorable apex court said that service book, the employer, the person against whom they have found this anomalous, he may be called to rectify all these things, verify all these things. Then you come to a conclusion. But here, nothing. Suddenly impugn order issued, and I'm in place before 7 years of my retirement, my lord. Next citation, my lord. My second one is, my lord, number 2, my lord. This is Sanjay Kumar Srivastava versus Central Coalfields, reported Air Online 2020 Jharkhand 958, para 9, 10, and 11. Very small paragraphs, my lord.
Yes.
Last page. In the case in hand, the respondent CCL is raising the issue regarding discrepancy in the date of birth of the petitioner, the two after lapse of 30 years. Mike is 33 years, my lord. 30 years from the date of appointment and at the fag end of the service career of petitioner, which is not tenable in the eyes of law. Number 10. The Honorable Apex Court, in case of Chennai Metropolitan Water Supply and Severance Fraud, address and so reported 2014 SC. The observation of the Honorable Apex Court, it is here below. Thus, the doctrine of delay and laches should not be lightly brushed aside. A writ court is required to weigh the explanation offered and acceptability of the same. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of citizens, but simultaneously it is to keep itself alive to the preliminary principle that when an aggrieved person without adequate reason approaches the court at his own leisure or pleasure, the court would under legal obligation to scrutinize whether a lease is a belated state should be entertained or not. Be it noted, delay comes in the way of equity. In certain circumstances, delay and laches may not be the fatal, but in most circumstances, inordinate delay would only invite disaster for the litigants who knocks at the doors of the court. Delay reflects inactivity and inaction on the part of the litigants who has forgotten the basic norms, namely the procrastination of the greatest thief of time. The second law does not permit one to sleep and rise like a phoenix. Delay does not bring hazard and cause injury to the lease. 11, my lord. As the secretary of the aforesaid resolution, rules, guidelines, legal proposition, and judicial pronouncement, the impleadment exchange is not tenable in the eye of law, and the same is here to quash and set aside. The respondents are directed to act as per the date of birth, pension, in a service expert in the petitioner essential. Here, my lord, squarely cover my case. The observation relied by this Honorable High Court and the Honorable Apex Court, my lord. This is a case of 30 years. They have taken this action, my lord, interfered by the High Court, my lord. My lord, more than 3 years more, my lord. That is 33 years of rendering of service, my lord. That not sure, my lord. And suddenly I'm being placed to superannuation, my lord. So this observation also supported my case. My third case is, my lord, Oriental Insurance Company. This is Prabodh Chandra Hazarika 2007, 1 GLT 142. That is Division Bench of a High Court, para 11 and 12, my lord. My lord, Justice B.S. Reddy and Justice B.P. Katuki, my lord. Para 11 and 12.
Yes, please read.
Yes, my lord. The fact that the corrected age and consequently the date of birth was accepted by the appellant insurance company is also evident from the seniority list published on Swencho as well as Swencho, wherein the date of birth of the respondent with petitioner has been reflected as Swencho, though in the seniority list published by the appellant as on Swencho. There is a typographical mistake regarding the date of birth which is shown as Swencho 49 in place of 49. It is also evident from the judgment passed by the learned single judge that except making necessary correction in the service book of the respondent with petitioner, the appellant insurance company has in fact corrected all other records, including the record of payment of income tax as well as the provident fund. The said position has not been disputed by the appellant insurance company either before the learned single judge or before the court. Therefore, it is evident that appellant insurance company, for all purposes, has accepted the date of birth of respondent petitioner as 10 so on the basis of corrected matriculation certificate relating to age issued by the Gauhati University of so which was within the 2 years of the entry in the service book of the respondent petitioner, which the learned single judge is rightly directed to be corrected in view of the aforesaid fact and circumstance. Hence, it cannot be said that the petitioner has applied for correction of date of birth at the fag end of this career by filing a reply to the so as contended by the learned senior counsel for the appellant. The contention of the appellant that as the aforesaid seniority list contained a disclaimer, the entry relating to the date of birth has to be as per the service book also cannot be accepted for the reason that the note appended to such seniority list is not a disclaimer, but for the purpose of correction of any entry inadvertently crept in. The appellant company, as discussed above, reflected the corrected date of birth of the respondent with petitioner in consecutive seniority list published, apart from the reflecting the same in other service book. Next para. There is no dispute about the proposition of law enunciated by the Apex Court in its various judgments cited by the learned counsel for the parties, and hence same are not discussed in detail. The Apex Court has held that it is open to an employee to seek correction of date of birth originally entered into the service group on the basis of unimpeachable and irrefutable proof of support of such claim. However, such claim cannot be accepted at a belated stage, that is at the fag end of the career. Here also, my lord. career. The fact and career, the department has no right to raise this point, my lord. This is honorable imprisonment service. In the instant case, as discussed above, the learned single justice found that after the Gauhati High Court, University authority issued the corrected matriculation certificate that such age is essential, the same was placed before the erstwhile insurance company and was in fact accepted and acted upon. From discussions made above, it is also evident that the appellant insurance company had also accepted and said corrected its certificate, and consequently the date of birth of the respondent and petitioner essential on the basis of corrected matriculation certificate. The appellant insurance company has not challenged the existence of such corrected matriculation certificate on age, consequently the date of birth respondent and petitioner recorded here. That being, we are of the view that the learned single justice rightly passed the judgment and order impunity present appeal. The judgment passed by learned single judge does not suffer, and for the infirmary required to interference court, has the appeal filed by appellant insurance company dismissed. Here, my lord, clearly the division bench of the Honorable High Court, Gauhati High Court held that he could have raised this issue earlier, but not at the fag end of the date of retirement. You cannot raise this issue. The delay comes here, my lord. So, in my case also, my lord, after rendering of 33 years of service, they issued that impugnator are disputing my date of birth. My
Next.
number 4 belongs 4, my lord, 1970 Supreme Court 326, only one paragraph, paragraph 12. Supreme Court, my lord, 1970, paragraph 12. This is Ram Prasad Sharma of the state of Bihar. Only one remain, my lord. Paragraph 12, may I read, my lord? We agree with the conclusion arrived by the High Court, section 35 of the evidence which provides an entry in any public or other official book, register or record stating a fact, an issue or relevant fact, and made by a public servant in the discharge of his official duty or by any other person in performance of the duty especially enjoined by the law of the country in which such book, register or record is kept, it itself is a relevant fact. In this case, it has not been proved that the entry in question was made by a public servant in the discharge of his official duties, as observed by this court in 1965. The reason why an entry made by a public servant in the public or other official record, books, register, or recording stating a fact in issue or relevant fact has been made relevant is that when a public servant makes himself in the discharge of his official duty, the probability of its being truly and correctly recorded in high, my lord. This is very important line. Yes, that means whatever they have correctly recorded in the service record in the year of 1988, it is correct as per Evidence Act, my lord. No proof has been laid in this case as to who made the entry and whether the entry was made in discharge of an official duty. And result, we must hold that so and so, so and so, so and so. That means, my lord, in the official capacity, in the official power, they have done all these things. They have examined all these things. They have offered appointment. They have given me an appointment, examined all these things, my lord. That means section 35 in my support. My final, the last citations, my lord, that is Air 1967 Supreme Court to 1269, that is State of Odisha, what is Dr. This, Binapani Day and others, paragraph 12, only one paragraph. Yes, the last paragraph. Sorry, my lord. It is true that some preliminary inquiry was made by Dr. Frenchel, but a report of that inquiry officer was never disclosed to the first respondent, that is to the concerned officer, my lord, against whom any action taken, my lord. And in that case, my lord, inquiry conducted, but here no inquiry. Thereafter, the first respondent was required to show cause why April Frenchel should not be accepted as date of birth. And without recording any evidence, the order was passed. We think that such an inquiry and decision were contrary to the basic concept of justice and cannot have any value. It is true that the order is administrative in character, but even an administrative order which involves the civil consequences, as already stated, must be made consistently with the rules of natural justice. After informing the first respondent, that is the delinquent officer, my lord, respondent of the case of the state, the evidence in support thereof, and after giving an opportunity to the first respondent of being heard and meeting and explaining the evidence, no such steps were admittedly taken. The High Court was, in her judgment, right in setting aside the order of the state to appeal this case. In that case, my lord, the action they have initiated without affording the opportunity, the Honorable Apex Court, if any such order passed without giving any opportunity by violating the national justice, it is one word is no value. This cannot have any value. This word used by the Honorable Apex Court. That means the impugn order passed is absolutely violates all the norms and guidelines made by the Honorable Division Bench, Apex Court, and the other high courts of our nation. That means all these things overlooked, my lord. And finally, my lord, I'm sorry, my lord, this recent judgment, my lord. I'm one of the counsel, my lord. I argued this matter, my lord. Similar kinds of issues raised on when I prepared this list of this is I could not sign up place.
WPC. WPC.
My lord, WPC.
5995.
Yes. Here, my lord. For the petition, I am a PK, my lord. The council, I am here, my lord. Here, my lord, paragraph 13 directly. 1-3. This is passed by the my lord Justice Manish Chaudhary, my lord, Honorable Justice Manish Chaudhary. Para 13, my lord. Sorry. Thus, from subsidiary rule 8C and from above decisions, it is found settled that the state has the authority and the power to refix the date of birth of a government employee, even though a different date of birth was accepted by the government at the time of appointment. But such a decision can be taken only after an inquiry undertaken in conformity with the principle of natural justice and fair play. Admittedly, absolutely, the same thing has not been done in my case, my lord. In the inquiry, the employee must have to be given a fair opportunity of meeting the case, and the principle of natural justice must have to be followed strictly, as the decision showed to be passed is likely to be visit the employee with civil consequences, my lord. It is settled that a disciplinary proceeding is to be conducted against any person with strict adherence to the statutory provisions and principle of natural justice. In the disciplinary proceeding, the employer should take steps at first to lead evidence against the charge-sheeted employee and give him an opportunity to examine the witnesses of the employee. Only thereafter, the charge-sheeted employee is to be asked whether he wants to lead any evidence and asked to give him explanation about the evidence laid against him. On receipt of the inquiry report, before proceeding further, it is incumbent on the part of the disciplinary authority to supply a copy of the inquiry report and all connected materials relied on by the inquiry officer to enable the charge-sheeted employee of the other, if any. It has been the Constitution Bench Managing Director, which is the case relied. Here, my lord, Honorable Gauhati High Court has held that if you found any anomalies in a date of birth so far as is concerned, you have to conduct an inquiry, give an opportunity. If you fail to conduct an inquiry, if you're not giving opportunity, it's a clear violation of strict principle of natural justice of law. And lastly, my lord, in the same judgment, paragraph 16. Well, I skip this. Same thing, this honorable court had got it. I'm summarizing my argument, my lord. Lordship, my prayer, page 18, of the petition. 18 minutes. My first prayer aim, Lord. Actually, a writ of nature of certiorari shall not be issued, setting aside the impugn order dated so and so annexure 4 issued by the concerned respondent. That impugn order for quashing action. Number 2, my lord. The writ in nature of mandamus shall not be issued, directing the petitioner that the petitioner shall continue to discharge his duties as Jamadar in the Office of Food Corporation of India with all service benefit. That means from which date they place me under superannuation. From that onwards to till my finally I'm entitled for the retirement, my lord, as to the 31st July 2021, I'm entitled all these benefits. And since 2021 to till date, what about the benefits? What about the service benefits, salaries? I'm entitled. I'm praying for this direction. And moreover, my lord, this is more important. Normally, Honorable Court exercise very in rare case, my lord. Suppose, my lord, petitioner failed to make some prayer in the petition, but this Honorable Court under 226 had ample power to exercise certain power, certain rights, my lord. My lord, in this case, Safaiwala, my initial, I'm Safaiwala. I just claimed the office. This is my, and they have welcomed me, or given, offered, and conditions. I fulfill all conditions. They have recorded my 24 July 1968. They are happy with my these records, and I'm being allowed to continue till my date of impugn order. In the meantime, medical identity card issued after examining my date of birth. That is also my correct date of birth is there. In the meantime, all pay slips, my date of birth, my date of retirement, all these things clear, my lord. Till even 31st July 2021 also, my date of birth returned 31st July 2028, and CPF account, contributory provident fund also, same correct date, everything as per the information I placed before the authority, my lord. For the last 33 years, they've never been questioned by the authority to me, my lord. Even that impugn order surprisingly issued, and moreover, my lord, when a person take for LTC in the department, I have to submit all my testimonial, my date of birth, all these things I have to place before the authority. After satisfying my birth records, all these things, they issued, they allowed the grant LTC to me, my lord. All, if your lordship, in the service book, last occasion, my learned senior friend has placed before this court the service record. Yes, lordship. For lordship, this service book, my learned senior friend has placed before this court. In entire service record, I have marked it, my lord. My date of birth is written 24 July 1970. Sorry, 68. 68. My lord, I will take your lordship to the service record. My lord, the person that insists, that officer, whether he's competent to issue such kind of order, whether ever he sought any permission or authority from the higher authority that this anomalies I have found. So you kindly allow me to pass this order. Whether he has placed any application before the authority concerned, this anomalies I found in service record. Please, I'm proposing you committee held and discuss all the issue. I'm going to place this matter committee and also ask that official also. No, no, it is all silent. The affidavit of opposition is silent. Whether any committee they have ever been made any prayer by the this that impugn order passed by the authority? No. Why after 33 years? By delaying which document has passed this impugn order, my lord? If this honorable court found that this impugn order is illegal, violation of natural justice, illegal, and I'm entitled all the benefits which is due to me since 2001 and remaining period since 2028. If the person who has committed this wrong done as per the prayer number C, the department initiate process inquiry against that concerned officer. Why violating this all these norms? Why On what authority that impleadment order he has passed? It is the power of this honorable apex court, this honorable court. Lordship may pass on this point certain observation. I'm praying to make some observation against the concerned officer. No, my lord. Service book.
Was any interim protection given?
No, my lord. No. But interim, my lord, I'm being.
No. Here you have an interim prayer.
No,
So
no,
did
no,
did you press that prayer?
No, my lord.
No.
No. No, my lord. Wait a minute. In service record, my lord, I'll place, my lord. I have marked it. Service record.
This one, the history card or?
Yes, my lord. Lordship, can I mark it, my lord, for lordship? Yes. এখন দিও লাগিব। My lord, can I highlight?
Yes.
एक मिनट।
Let your associates do it. You continue.
Yes, my lord.
Yeah.
Good. Jenny, Jenny mark করে দিও। Okay, mark করো। এটা করো। Page 20. Next place. Next place. Okay. Then you come to this annex. This it is different from records. Take. Mark it. Highlight. Highlighting. This is very next page. Yes, 7. Let mark করে দিও। No, not here. Very next page. This page. 7. Date of birth. Next, history card. Only 2-3 moments. Sorry. 2-3 moments. History. Take on. Marked it. The second page. 24 July 68. Right? Not report. This space. Biodata. This space. Yes. Highlight. Yes. Next. Service book 3, volume 3. That is. Service book 3. Is it problem? Service book 3. The second document. Icon. Pink color. Not this. This is. Take a issue question mark one. This is last mark. Medical identity card. Medical identity card. Photo. Photo. July 68. Okay. I will come to my program. Plus 9 minutes. Okay, my lord. দেখুন আছে আরো কোন আছে Lord, the first service book as per their records, medical records, date of birth.
Yes.
Yes. 24 July 1968, as per your office records, my lord. Next mark, I have marked it, my lord. The cardex form. Lord, you will find my date of birth,
6/7.
but month and year is same. July, where concerned year, July 68, 20, instead of 2026. Next, my lord. Master updation review form, my lord. Master updation form, my lord, you will find serial number 7, date of birth.
24/7.
Yes, as per office record. Serial number 7.
But here, date of retirement is given as 2021.
My date of birth, serial number 7.
Date of birth is 7, date of retirement
Date of-
is 20.
My lord, date of joining, my lord, 26 July. Here, my lord, well, petitioner fill out, my lord, it is fill. 21 it is real. If you consider the date of birth is 24 July, as per this serial number 7, 28, my lord, it is 28. This accidentally, my lord, it is 10/21, but by date of birth, as per all previous all documents, it is 31st July. Next, my lord. This is the contributory profit and funds record, my lord. My date of birth 24 July 1968. Next, my lord. My joining report 26 July 1988. The bottom Roman 5, attestation form in duplicate in an XR form. That document, my lord. The lord, you will find my date of birth in the attestation form is 24/7/1968, my lord. Okay, my lord. Next, my lord. My another marking, that is history card. In history card, lord, you will find short card, yes, date 7, date of the Christian era, 24 July 1968, my lord. Got it, my lord? Yes. Next, my lord. In my third volume 2 service book. Yes, serial number 8. Date of birth with birthplace district in 24 July 1968, my lord. Volume 2, my lord.
Yes.
Biodata. Next, my lord.
Medical
Volume
identity.
3, service book. This is the final service book. Here also, my lord. Serial number 8, date of birth 24 July 60, issued when, my lord? That is bottom, my lord, very important. This is on 2019, my lord. Certificate issued on 2019. My date of birth 24 July 68. That means 2019. It is in the service record 24 July 1968, my lord. Then, my lord.
Medical identity. Next is medical identity
And
card.
next, my lord, there is a medical identity card they have issued to me. Issued to me, my lord. Deepak Sarkar, date of birth 24 July 68, my lord. Very next page, my lord. They have issued 14/6/2021, June 21, by Assistant General Manager. My lord, that means 14/6/2021, as per the official record, my date of birth 24 July 1968, my lord.
What is this annexure? Annexure 1.
Yes. This is a medical identity card. And another page I have marked it, my lord. My class 9 serial number 12, my lord. Class 9 pass at the time in 1982.
Serial number 12.
12. Class 9 pass. 82. Yes, my lord. June 2021, after more than 33 years of service, they themselves issued my date of birth 24 July 1968, as per their service record itself. Two documents they have enclosed in their Philippine opposition, Annexure C, Annexure E, like this. One employment action certificate. My date of birth is in 60. If that be so 1960, why this authority has offered appointment to me in the year of 1988? If they are in doubt. And if they are not satisfied with the document, then they could have, very initial stage, they could have raised this issue. Since such a premature retirement, such a strict action you have taken against me, but without affording the opportunity to hear me, without prior intimation to me, that we are going to take action against you. But Honorable Apex Court, as well as Honorable Division Bench of Law, as well as Honorable High Court, has from time to time has said that and interfered with any such date of birth related to issue raised by the corporation by authority after 30 years. It is no value interfered. So my case, my lord, after rendering of 33 years of service, without prior intimation to me, without hearing me, violating all these norms, overlooking all these testimonial this service book, I'm not a custodian of this service book. I'm Safayola and Jamadar my posting is. Who I am to keep these documents? These documents is with you, sir. This is safe custody. It has never been allowed to show these documents to anybody. Then how you, without verifying all these norms, without conducting inquiry, without telling any committee, how this order you can issue this order? For some extent, I'm saying he's the competent, for example, presuming my lord, he's a competent authority. He may issue such kind of order, but the manner, it's not the violation of this all courts norms, all guidelines, service principle, natural justice, my lord. It is their service book. I have just shown your lordship. I am not a custodian of this authority. In the police inquiry, my lord, I have read your lordship, they have said they showed from complainants the contact number of that custodian. Why that custodian evidence is not in the report? That, yes, after getting information, getting contact number from the complainant, from the authority, we have inquired these custodians. Either from custodians, some materials they are able to collect. Yes, some tampering, something has been, illegality has been done on my part. It must be reflected. Inquiry report submitting, no, my lord, inquiry even when, then you are very much sure, beyond doubt. Then you have taken the statement, contact number from the custodians, but no evidence is. You have found in the FIR, the 2 dates we have found. So the previous date, 2021. So I am going to return. How? It's a very casual manner I am being this imperial order issued, my lord. And getting this news after 2 days, my mother expired, is stroked. Charity is stroked. I have enclosed her death certificate. After 2 days, she was a healthy person. And even, my lord, after this imperial order, my lord, from 21 to 2022, door to door, I approached before the authority to get the information on what basis you have premature retirement order you have passed to me. You furnished me all these documents so that I could satisfy. They refused. I've shown this refusal order. If they are genuine on their part, they could have said, yes, see this. Say this. You have tempered this document. Then question would have been different, my lord. But neither, yes. So moto they have taken this decision without affording opportunity. Surprisingly, my lord, without initiating the departmental course to save their skin, lost FIR, my lord. The question of has come when? When it is all corners, it is proved. I have tempered. No inquiry have conducted, simply one lost FIR. And in the FIR, this police report, concerned authorities evidence you have not taken, and FIR report, how report in the police authority can say this statement that the 26 and 27 he is eligible. How 26 is absolutely the violation norms of the FCI, my lord. It is the 25 is the outer limit of the to get the appointment in the FCI. From 18 to 25 is the age limit. How in the inquiry report it is? This is not the issue of the engine. I am eligible or not. He's only concerned whether any material he has obtained or acquired or not. That inquiry process absolutely silent. That is, we received when FCI department has filed FID opposition and closed this document. We received this. And my lord, my submission, my lord, let them, my learned friend, argue. If the age completion, the lordship, if lordship, I think to give any reply, then I will reply, my lord. So my humble submission, my lord, this imperial order may be set aside and quashed. And all I may be allowed to continue service till by actual date of retirement to 31st July 2028. And what about the due benefits since 2021 onwards? Same may be released to me, my lord.
Imti, you have a matter.
Yes,
I don't think we'll be able to reach.
item 26.
Yes, yes.
Can it be fixed? Day after tomorrow's first item? Item 26.
Everyone wants their item as first item. Wednesday will be
11.
11th. I don't say first item, just say it's a fixed matter.
Not so.
Next week.
Yes, next part, I'll be at the common school.
You'll be out of station.
Yes,
I'll be at
forest school. He's going for forest school.
Then-
Why? I have to accommodate.
Okay, then, when?
Monday?
Next week, 19.
my law, next week.
Next week, 19.
Monday.
No. Yes, 19, no? 19th.
March of what?
Yes.
Your Ladyship. Without going into the facts of the case, initially, I would like to raise objections on the maintainability of this writ petition. Firstly, on the ground of suppression of material facts in this case. The petitioner, in this instant case, in his writ petition, paragraph 2, he stated that he was initially appointed, paragraph 2.
Your affidavit in opposition.
No, their petition,
Oh,
their writ petition. Page number 6, paragraph 2.
yes.
I'll read it out to you, Your Honor. That the petitioner begs to state that the erstwhile office of the Food Corporation of India Regional Office, Northeast Frontier Region, Shillong, by so and so, order dated 13/7/1988, issued an offer of appointment for the post of Sabaiwala in the Food Corporation of India to the petitioner, and thereby asks the petitioner to join after furnishing the copies of requested documents as listed herein, including educational and age certificates, etc., which is annexed as Annexure 1. Annexure 1 in the writ petition is it. Page 21, Your Honor. Page 21. They have put the type copy in page number 23, and the annexure is in 21. There in the paragraph number 2, Your Honor, and the last lines, and in the paragraph 2, in the last lines, and thereby asks the petitioner to join after furnishing the copies of requested documents as enlisted therein, including educational and age certificates, Your Honor. Till now, after a long and close submission by my learned counsel, they have not shown any document, or they have not exhibited any document on which they have shown on this day. The documents, all the while they were showing, was all of the 2004, 7, and 2021. But however, on the day of admission and on the day of interview, year back in 1988, they have not shown any documents. This is the content of dispute, my lord, your Ladyship, in this case. I would like to mention, when it comes to the ground of suppression of material facts, Your Honor, I would like to raise before this honorable court that where's the documents that they have annexed, produced, shown on this day, on the year 1988. There, I would like to take your lordship.
Why did you allow him to continue for 33 years then?
Then I'll bring to you, madam. Please come to my affidavit in opposition and affidavit opposition which I filed, and paragraph number 5, Your Honor. Paragraph number 5. Here, I would like to the objections on the maintainability of this case, which is suppression of materials facts. That is number 5. With regards to the statements made in paragraph 2 of the writ petition, the answering deponent begs to state that the petitioner was recruited as casual sweeper on daily wage basis with effect from 1978, Your Honor, not 1988. 4/4/1978, White Office order dated 7/11/1978, issued by FCI DO Imphal, and thereafter regularized to the post of Sabaiwala so and so in the year 1988, and the petitioner joined Sabaiwala as with effect from 26/7/1988, dated 30/08/1988, which I have annexed as Annexure A and B in my affidavit in opposition. Which is Annexure A, Your Honor.
Sure, A in
Page number 10 of my affidavit in opposition. This present petitioner, the writ petitioner, he was earlier appointed as casual sweeper on daily wage year back in 1978, Your Honor, 10 years back. This material fact has not been disclosed and has been hidden by the petitioner while coming before this honorable court. For this, I would like to mention that, madam, I'll read out for you which I have in type copy in page number 11. The original is in page 10 and the type copy in page 11. May I read out your lordship? Office order, Imphal the 7 number 1978. So and so is hereby accorded for the following persons to engage as casual sweeper on duly wage basis of rupees 6 only per day with effect from 04/04/1978 until further orders. And where the present petitioner is listed in serial number 4, Shri Deepak Sagar, son of so-and-so, Pumaken, Dimapur, which was issued in 7 number 1978, Your Honor. This material fact has been concealed, and this the petitioner has not come before this honorable court with clean hands. So, Your Honor, Your Ladyship, this clearly proves that the petitioner was initially appointed in 1978 as per this appointment order which we have, and not in the year 1988 as claimed by the petitioner. In his annexure, in his paragraph number 2, he has claimed that he was appointed in 1988, but which we state and proves you before the documents that he was appointed in 1978 as casual sweeper, casual employee. This clearly proves the fact that the petitioner was not born on 24/7/1968, because if he was born on 1968, Your Honor, during the time of his initial employment as casual employee in the year 1978, he was only 9 years. 9 years, 11 months, 9 years, 11 months, 17 days, when he was appointed as casual employee in the FCI, in the same FCI, Your Honor. It is impossible to imagine that a 9-year-old boy was able to pass off as a man of at least 18 years of age when he was appointed, Your Honor. That is 9-year-old, I repeat, madam, that it is impossible to imagine that a 9-year-old boy was able to pass off as a man of at least 18 years of age when he was appointed. So, Your Ladyship, all this clearly proves that he has suppressed material facts and approached this honorable court without clean hands and clean mind. It is a well-settled principle of law that a litigant who approaches any form of law without clean hands and clean mind and after suppression of material facts is not entitled to any relief. And in fact, such litigant is not entitled to be heard at all. It is our prayer that Your Lordship, Your Ladyship, the petitioner should not be allowed to receive any benefit out of fraud, forgery, and misrepresentation perpetrated by the petitioner. Also, Your Lordship, this appointment of the petitioner as casual employee, Your Honor, is not denied by the petitioner, by the petitioner, even in the affidavit in reply, paragraph 2. Madam, may I lead you to your paragraph 2 of the affidavit in reply made by the petitioners, which is in paragraph 2 of the affidavit in reply. Paragraph 2, Your Honor. With regards to the statement made in paragraph 1, 2, 3, 4, 5, the paragraph 5 is our statement when we have stated that he was initially appointed as casual employee way back in 1978. Paragraph 5, to which the answering opponent has not contested, rather they have given no comments, Your Honor. And the petition also, in the writ petition also, they have suppressed this fact. And when we have listed out this in our affidavit in opposition, they have offered no comment. They are silent on this, Your Honor. So, Your Honor, The petitioner has approached this honorable without clean hands and a clean mind. The petitioner has made a false statement on oath, and which is also a case of misleading this honorable court amounts to perjury. As such, it is prayed that this honorable court may be pleased to dismiss this instant writ petition with cause. Madam, with cause, as the writ petitioner has clearly suppressed material facts and has approached the honorable court without clean hands and a clean mind, and also making a false statement on affidavit on oath, which is on oath before the honorable court. Your Honor, a document, I would like to just, Your Honor, to satisfy the honorable court, I would like to place some documents, relevant documents, which the petitioner has overridden in the civil books and in the documents which has been placed before honorable court. The honorable court initially, when the Xerox copy is shown, may think that it is a fair copy. But if only we show you the original copies, which is brought before you, I would like to place it before honorable court, one after another. Your Honor, the flag pages, serial number 7. Serial number 7. Date of birth as office record is 24/7/1968. Madam, we can clearly see that it was 1, which they have tempered it to 8. With a perusal in the original copies, we can say that the serial number 7, the date of birth as 24/7/1968, which is shown, bloated, overridden, and Xerox copies, can be seen clearly in the original that it is 1, which was overridden to 8. Further going down to serial number 20 in the same page. Serial number 20, date of retirement is 2021, which we readily the impugnator, which we readily subordinated him from service in 2021. It is not, and many documents, madam, you can see that many documents they have tempered it to 68, but in many documents they have overlooked it and they could not temper it. They have not tempered it. Here, date of retirement is 2021. Madam, coming back to the next page. Serial number 10. Date of birth in CPF form. This is CPF form. Date of birth is 24th month is July. Year is
CPF form.
Yes, madam. In the year is, madam, even with our negative also we can see the overriding. 1961 has been clearly loaded, overridden to 8. And madam, these documents, I would like to repeat again that those documents which I'm placing before you are also all documents, 1980s, 90s document. And the petitioners whom they are relying now, the documents here, those are 8, 9, 10, 2021 documents. Aadhaar card, those are Aadhaar card, PAN card, those are service identity cards, are 2021 documents, Your Honor. Those documents which I'm placing it, exhibiting before the honorable court are those all documents which were initiated during the initial period of appointment. Then, my lord, if you come to my serial number 7, again, the attestation form. Attestation form, yes, which the petitioners have also relied. This form, which I'm placing it before you, if you come to the page serial number 7, Your Honor.
Yes, date of birth.
Date of birth is 24/7/1968. This one is also done with white ink. They're not only overriding, it can be seen that white ink was, correction pen was also used. And going back to the next page, serial number 10. Your Honor. Affidavit in opposition.
Yes.
And going back to the serial number 10, the next page. The school documents that which they have relied on. Number 10, after 9 and 10, the next page is shown as page number 3 in the documents that school documents that which they have relied is Vivekananda School.
School documents are not good.
Madam, have you got your leadership? Page 7,
Then, okay, okay.
7, serial number 10.
10.
Yes, they are the school that which they have relied that they have passed out is in the form is shown as Vivekananda. However, Your Honor,
No, serial number 10 you have given is the CPF form.
oh, Your Honor,
CPF form.
this one in attestation form, no? Where his passport is there, passport picture is there.
Attestation form. Yes, yes.
Yes. The first page, second page, and third page. Third page.
Oh, yes,
9, 10.
Vivekananda HE School.
However,
Serial number 10.
yes, Your Honor. This is the document that they all have relied upon while he was appointed. But however, please come to my affidavit, dear affidavit in reply in page number 3. Yeah, affidavit in reply, paragraph number 3, page number 3, the middle paragraph. Affidavit in reply, yes.
Moreover, the deportation.
Yes, may I read out to you, Your Ladyship? This is the Vivekananda documents they all have relied on while to get in that appointment, Your Honor, in the department. However, in this affidavit in reply number 3, may I read out for you, Your Ladyship? Moreover, the deponent begs to state that the class 9 certificate dated 31/12/1986, Annexure E of the affidavit opposition relied upon by the respondent authorities does not belong to the writ petitioner. See, madam, the blatant misleading. Does not belong to the writ petitioner, and the writ petitioner had never submitted the said certificate before the respondent authorities or any other authorities at any point of time. Moreover, the said certificate is not a legible one, and its contents cannot be read with full certainty. As such, the genuineness of the same is free from doubt. However, Your Honor, as mentioned in the service book, that the documents relied upon is in serial number 10, that it is from Vivekananda. May I take your leadership to our affidavit in opposition, Your Honor, page number 19.
Annexure E.
Annexure E. Some parts are legible, some parts are legible. However, we have printed it out in type copy in page number 20, Your Honor. Your leadership, page number 20. May I read out for you? Assam School, form number 68. Certified that Sri Deepak Sagar, son of Tikendranath Sagar, an inhabitant of Pogajan, left the Vivekananda Higher Secondary, not legible, school on 31/12/75. His age at the date, according to the admission register, was 14 years, Your Honor. Here, his age at the date, according to the admission register, was 14 years, 5 months, and 7 days. He was reading in class 9, madam. He was studying in class 9 and has passed. And it passed. He passed a examination for promotion to class 9, class 10. All dues due by him have been paid and so, Your Honor. So it is good that Mr. Deepak Sagar, in the year 1975, he has passed class 9, Your Honor. And that time his age was 14 years, 5 months. And subsequently, it is also shown here that he was promoted to class 10. Then if this same person, if his age was 1968, then he should not have been the same person who has come before this FCI for appointment or for interview, Your Honor. Because the age doesn't align. Rather, his age will be around 19 years. If he was 68, he was born in 1968. But this certificate clearly shows, and this is the document which we have with us in our service record in the office of the FCI in Shillong and Dimapur also. This is the document we have of Mr. Deepak Sakar, and he has not produced this document before your honorable court. Leaving aside the 10 years which he has worked before as casual employee, Your Honor, this document has also been hidden. But we have the document as such, we have brought it before your honorable court. Besides that, Your Honor, besides that, in my affidavit in opposition, I've also annexed a document which is in page number 16, annexure C. Which was issued, the date of registration is shown as 1985. And there also, the date of birth 1960 is found tempered. However, when he was called for interview, which is found in page number 18, Your Honor. Page number 18, annexure T. He was called for interview for regularization. May I take your lordship, may I read out for you, please? Dated 2010-87, interview proceedings. In order to regularize the service of casual employees, and casuals, madam, here is from casual employees. When that means Deepak Sakar, because he was working from 1978. So it is hidden here in this petition. To show the regularize the services of casual employees, interview test of Sri Deepak Sakar, sweeper, water carrier, presently working under District Office FCI Dimapur was held by the following committee of officers and Regional Office Shillong on 2010-87 under the chairmanship of Senior Regional Manager. Here it is shown. His date of birth is 26/2/60 as per employment card, which is I have annexed it in page number 16. There are observations.
22/6/60 and then on 24/7/61.
61 is as per the admit card. This admit card, madam, that is education admit card. Though they have not shown in brought before the honorable court, see, even the examination board has also deliberated his two date of births. Difference in date of birth, 2, overriding in certificate at the time of entry was, he was underage. Your Honor, they have also discussed that if 1961 was to be considered when he was employed as a casual employee, that time he was not, he was below 18. This is also. Number 2, Your Honor, he has produced copy of certificate stating that he has read up to class 9. This, which they are stating that this past certificate, which I have annexed in page 19. Class 9, see, Your Honor, he has produced copy of certificate stating that he has read up to class 9. Number 3, Your Honor, he is an FCI service on casual sweeper, water carrier with effect from 4/4/78, Your Honor. For the last 10 years, he was working as a casual employee, and since then, he is continuing in the post of casual sweeper, water carrier. Number 4, he was appointed by so and so, Your Honor. Number 5, he is not a ST/SC candidate. He has registered his name in the employment exchange, void number so and so, which I've annexed in annexure 6, page number 16, annexure C, that employment card. Number 6, I feel that it's not material. It presents their sanction post of 7 and so and so and so. Number 7, since he's a casual employee, Your Honor, therefore question of examining his years does not arise. Your Honor, number 8, this is pertinent, which my learned friend is also raised this issue. As per IFSA staff regulation, the prescribed qualification, the sweeper in the scale of should be able to read and write and any language with an age limit of 25 years. Your Honor, in this case, his age limit has to be 25 years. But if considered that he was born in 1961, as was the office is taken, he is above 25 years. However, as per the rules of the FCI 1971, those employees who are working, or those who are ST and SC, he was little above 25 at this point of time. However, Your Honor, and page number 1 is category for boss. And coming to my page, next page, Your Honor, serial number 13 is the sweeper. Serial number sweeper, Safai Bola, which the present petitioner, the petitioner, he is holding the post. And the next page, note, the last page, note, the third line, relaxable, Madam, may I read out for you? Relaxable in cases of departmental employees by 5 years, Your Honor. And further, relaxable by 5 years for departmental employees belonging to SC and ST. So this, at this point of time, Your Honor, to Mr. Deepak Sarkar.
This is from where? Regulations.
1971.
1971 regulations. This one.
Yes, yes. Your Honor, as such, this present employee during this interview proceedings, though he was little, if his age is considered as 1961, though he was a few months or years, 1 to 2 years elder than the 25 years, he was considered because there was a relaxation of 5 years for the employees or ST and SC category.
Yes.
Madam, in regards to this case, before I read out my other citations, I would like to place a citation only on this suppression of fact and regarding this disputed facts in which the petitioner. I'll just.
No, one question is, assuming that there are overwriting and all that, did the authorities conduct any inquiry?
Yes, Your Honor. In this case, there was no
Because
pending.
whatever it is, he was a regular employee.
Yes. So he was retired owing to his superannuation. So there was no need for conducting inquiry because there was no pending case against him. There was no pending litigation or there was no inquiry pending against him. But as per the records, perusal of the records, it was found that he was due to retire on this date, so he was given retirement. Fairly. There was no pending case or litigation or inquiry in the department. Your Honor, before coming to my other submissions regarding these distorted facts, I would like to bring you this judgment because this judgment is very similar to our judgment, Your Honor. This Arun writ petition 3 civil 5042/2018. Our Gauhati High Court, Arun Chandra Sakya versus State of Assam and four others. Dated was 4/4/2025. Recently, Your Honor, just recently, this 4/4/2025. May I read it out from para 2, Your Honor? Though it is not a long judgment, so for the comprehension.
Para 3.
Para 11. Madam, para 11. The petitioner's date of birth as recorded in his service book at the time of joining was 31/7/1958. And in terms of the state date of birth, the petitioner should have retired on 31/7/2018. The petitioner was, however, taken to understand that his date of birth is 01/12/1967, as recorded in the HSLC admit card and HSLC certificate. Further, the Secretary Board of Secondary Education, Assam, had apparently written a letter dated 29/4/2017 that the petitioner's date of birth was 01/12/1967. It is also a fact that the petitioner had joined the government service on 5/11/1976. It is also a fact that if we are to assume, Your Honor, if we are to assume that the petitioner's correct date of birth is 01/12/1967, then the petitioner is to retire from government service on 30/11/2027. That is, after being in government service for 51 years, Your Honor. I'll repeat again, Your Honor. If we are to assume that the petitioner's correct date of birth is 01/12/1967, then the petitioner is to retire from government service on 30/11/2027. That is, after being in government service for 51 years, in which case he would have been a private citizen without any government job for only 9 years of his first 60 years of his life, Your Honor. It is impossible. It is impossible for a 9-year boy of 9 years to be appointed into government service unless his physical features showed the appearance of a person being 18 years or older. It is the case of the petitioner that he was appointed into government service at the age of 9 years. My lord, may I repeat again that one? It is the case of the petitioner that he was appointed into government service at the age of 9 years. His physical attributes at the age of 9 years would have been there for all the world to see that the petitioner was a young boy. His colleagues and the officials would have been all seen that the boy could not have been appointed to government service. Para number 12, Your Honor. Interestingly, the petitioner has not annexed any of his appointment, transfer, promotion orders in the writ petition, though the letter dated 15/5/2018 issued by the district elementary education officer shows that the petitioner has joined his service as a personal peon on 15/11/1976 and the scale of so-and-so per month in the office of the Deputy Inspector of Schools, Nagon. He was transferred to the office of the Deputy Inspector of Schools, so-and-so, by dated 04/1983 and joined his post at the office of Deputy. Madam, I'll come down here to the last 4 lines here. The same paroni. None of the documents, Your Honor. None of the documents have been annexed by the petitioner. Same case like ours, Your Honor. Though they have filed a writ petition, but none of the documents that which he has entered into service has been annexed by the petitioner. The above service particulars of the petitioner have been recorded in the letter dated 15/5/2018 issued by the District Elementary Education Officer, Sipsa Sakar. My lord, coming back to para 14. May I read that para 14, Your Honor? On considering the fact that the petitioner had been appointed as a personal peon on 15/11/1976 and the scale pay of so and so per month in the office of Deputy Inspector of Schools, Nalbari. It is very clear that the petitioner could not have been 9 years of age or at that particular period of time. Like us, he should not have been 9 years when he was a casual employee, when he was appointed as a casual employee. The entire office in which the petitioner appointed would have instantly realized that there was something wrong if the petitioner had trained his boss as a 9-year-old boy. Madam, para 15. I will read it to you, only the relevant portion, the last 4 lines, the paragraph 15, thus, from thus. Thus, the above fact raises a further question as to how a 9-year-old boy who was in class KG or class 12 will have been appointed to a grade 4 beyond boss in the government on a regular scale of pay, and how a 9-year-old boy was able to pass off as a man of at least 18 years of age. Madam, may I take you to the next page? Page number 8. Is the 7th from the 7th line. It is also to be kept in mind that fraud, madam, fraud vitiates everything, Your Honor. It is also to keep in mind the fraud vitiates everything. The issue of fabricating documents needs to be gone into also. As such, the petitioner's date of birth, for the reasons stated above, cannot be 01/12/1967. Consequently, the petitioner cannot be allowed to receive any benefit out of fraud, misrepresentation perpetrated by him, and probably in connivance with certain officials, authorities in the government of Assam, and also the Board of Secondary Education Assam. This same court also observed, Your Honor, para 17, may I read out the first lines? This is para 17. This court is accordingly of the view that a thorough inquiry should be initiated by the state respondents as to how such a thing came to pass. Though it has been stated by the state respondents that instructions have been issued on so and so to cancel the correction of the petitioner's date of birth. Direction was also issued for a thorough inquiry, you know. May I take the page, para 18. Para 18, Your Honor. In this case, the petitioner's date of birth recorded it in the HSLC admit card and HSLC certificate and the letter of Secretary Board of Education Assam stating that the petitioner's date of birth was 01/12/1967 could not have been correct, as the petitioner could not have been appointed to a regular grade 4 post of peon on a regular scale of pay at the age of 9. Para 19. In view of the reasons stated above, the record is of the view that the petitioner's date of birth as recorded in his service book, Your Honor, when he joined has to be taken as his correct date of birth. Thus, the petitioner should accordingly have retired on 31/7/2018. At this court, as this court has directed the government to have a thorough inquiry into the matter, our government should also consider as to whether there should be a recovery of the salary paid to the petitioner with effect from the date of retirement, as he was to actually retired by 31/7/2018. As such, Madam, even in this petition, in this writ petition also, initially it was prayed for staying the impugnator and for continuing in the service. However, the Honorable Court, initially while admitting this writ petition, has also not given this relief of staying the impugnator and allowing the petitioner to continue in service, because later on also it will be difficult to realize those salaries or those privileges if the petitioner should have wrongly can. Your Honor, if I come to your history book regarding the Madam, if I have to take you to the
Here, the grievance was that his date of birth has been wrongly entered in his service book. The petitioner said that his date of birth has been wrongly entered in his service book.
Yes.
But in the present case, he said that it was the right date of birth, but the authorities have gone against that. That is the difference.
However, my lord, I want to mention that if this petitioner, if he has worked as a casual employee, which is there in the record, since 9 years old,
That I have taken note.
madam, 1 second, if since 9 years old and working for another 33 years, that is 42 years. And if he's going to work another 7 years, for 50 years, he'll be continuous service in his age of 60 years. The present petitioner is now 55 years. When he's filed the affidavit in his affidavit in the writ petition, he's 55 years. So far, he has worked for 43 years. And if he's to work another 7 years, and it's 60 years of age, when he's about the 60 years of age, another next few years, he should have worked continuously for 50 years. If we have to calculate fairly, you know, and that would be very rare. Working for 1-2 years or 30 years or 35 years is 40 years, okay, but working continuously a human person for 50 years since the age of 9 is impossible. Cannot be. It's not only a surprise. It's a very rare case, you know. So I would also like to place on record that it has been tempered. It has been bloated. I would like to take you to your lordship to the service book in original. The first page, Your Honor. This is the original. The petitioners are relying on this service book as well, history book, but which can be evidently said that it has been tempered. It has been overrating is there, Your Honor. 24 July 1968 is shown, but it can be, if we look closely, that 1 has been made into 8. However, the next line, the serial number 8,
Education qualification.
class 9 pass. Though they are denying that, Your Honor, but we have exhibited and shown before you the class 9 pass certificate. And if they are denying the one which I have exhibited in my affidavit in opposition, Your Honor, they should be ready to show it before your honorable court, whether it is lost or found or tempered or mutilated or in any form. But so far, they have not placed any documents regarding the class 9 documents which we have placed before you. And the documents which was placed before you was there in Shillong office, which was brought on the Dimapur and it's been exhibited before you. The 1968, all the while the petitioners are relying on is the tempered 1968 or else. And most of the documents, even which we have annexed, Your Honor, and on affidavit opposition in page number 30, page number 30.
Page 30.
GPF, CPF 2003-24. This 2003 to 2004 documents, Your Honor. The petitioners were placed to show the documents of 2010, 11, 2020, 21. But these are the old documents, which is shown as 1961, the date of birth.
Yes.
Yes, Your Honor. And this document, it is shown that the family members of the petitioner is shown along with his mother and children. Here, the date of birth of the petitioner without tempering is shown as 24/7/1961, clearly.
What document is this?
Regarding this is for family pension documents to submit it to be when submitted to the office. 10. Many documents have not been tampered, Your Honor. Many documents have not been tampered, is shown as 1961. Many documents have been tampered wherever possible, but many documents have not been tampered, to which I am reflecting it before your honorable court. This here is shown as 1961. And coming to my next page, Your Honor.
Make sure one.
Yes, no.
This
This,
is the same thing.
yes. There's a letter 6 October 1987.
6 October. Here in this compilation.
6 October 1987. This letter also shows that, though they have not stated that he was a casual employee, this letter also shows that Mr. Deepak Sarkar in 1987, he was sent this letter for interview test to regularize his service. He was appointed in 1978, and this letter shows that he was a casual employee and he was called for regularization in 1987.
Yes, what else?
Your Honor, regarding the separation of material facts, I would like to place before you a judgment. Order 33 and 35. Order 33 and 35. Order 33 and 35, Your Honor. This observation is made by our honorable court, Your Honor. May I please read it out, Your Ladyship?
Yes.
Para 33. It is thus clear that though the appellant company has approached the High Court under Article 226 of the Constitution, it had not candidly stated all the facts to the court. The High Court is exercising discretionary and extraordinary jurisdiction under Article 226 of the Constitution. Over and above, a court of law is also a court of equity. It is therefore of utmost necessity that when a party approaches a High Court, he must place all the facts before the court without any reservation. If there is suppression of material facts on the part of the applicant or twisted facts have been placed before the court, the court may refuse to entertain the petition and dismiss it without entering the merits of the matter. Coming to para 35, Your Honor. May I please, Your Lord?
Yes.
It is well settled that a prerogative remedy is not a matter of course and exercising extraordinary power. Therefore, a writ court will indeed bear in mind the conduct of the party who is invoking such jurisdiction. If the applicant does not disclose false facts or suppresses relevant materials or is otherwise guilty of misleading the court may dismiss the action without adjudicating the matter. The rule has been evolved in larger public interest to deter unscrupulous litigants from abusing the process of court by deceiving it. The very basis of the writ jurisdiction rests in disclosure of true, complete, and correct facts. If the material facts are not candidly stated or are suppressed or are distorted, the very functioning of the writ courts will become impossible. As such, Your Honor, I repeat that this honorable court, on the grounds alone of the separation of material facts and recourse before honorable court, this instant writ petition ought to be dismissed with cause, Your Honor. My other ground of submission will be, Your Honor, delay and laches and coming before honorable court. It is, Your Honor, it is humbly submitted that the impugned office order was issued by the respondent authorities on the 2nd of August 2021. However, interestingly, Your Honor, this writ petition has been filed in the year 2024. The person who was so much aggrieved to the extent of that he could not comprehend his subordination. He came before this honorable court after a lapse of around 3 years in the year 2024. The writ petitioners had all along, Your Honor, the petitioner had all along accepted the court order dated to August 2021. Between the date of subordination, Your Honor, and date of filing the present petition, there is long date in filing the instant writ petition. It is also, Your Honor, it is also pertinent to mention that the petitioner has submitted a representation. However, it was submitted only after the officer in charge of the police station summoned him. When the officer of the police station summoned him for criminal culpabilities over investigation, there only he represented a submission before the authorities to cover, to shield himself from any criminal investigation or culpability. As such, on 6/10/2021, the matter to investigate the cheating, tampering of server spoke, and after he was summoned by the investigating agency, as an afterthought to save himself.
Should we continue tomorrow?
Madam, I'll finish. Just give me 5 minutes. Just give. So, Madam, there's delay in latches. I want to mention that he's written few RTIs, but those RTIs also has been answered to the extent of commission. The commission also rightly stated in the RTI that we cannot give you the information because it is under investigation. Article Section 8(1)(h). Section 8(1)(h) is there. The commission is also stated that they cannot give you the information because it is under police investigation. The petitioner finally is coming before this honorable court to shield himself and to hoodwink his criminal or liability or prosecution. Madam, finally, my submission will be on disputed questions of facts. It is finally my objection will be on disputed question of facts. The question of facts is the date of birth is one is 1960, one is 1961, and one is 1968. The present case of changes in the date of birth of the writ petitioner is being investigated by the police on the grounds of cheating and tampering of records, manipulation of data, and for criminal against the corporation. As such, it is a clear case disputed of facts, Your Honor. This honorable court, the Honorable Apex Court has laid out in series of decisions that when it's a matter of disputed fact, it is to be adjudicated by the appropriate court or the civil judge, Your Honor, whether to call witnesses or to take evidence. As such, this honorable court is one of jurisdiction when it is a disputed fact of question of facts. As such, it is earnestly prayed that this honorable court, on this ground submitted above, that it is a fit case to dismiss at this stage for separation of material facts. Genuine, tangent material facts they have suppressed. Besides that, there is a delay and latches of filing the instant petition. Besides that, disputed question of facts. As such, it is prayed to dismiss this petition with appropriate cause in the interest of justice.
My lord, I will take only 1 minute. It's 1 or 2 minutes.
This is on.
Para 16.
The para only.
Para 16, Your Honor.
Lord. In my 2 minutes reply, my lord.
Yes.
Only the moot point I will place, my lord.
Hmm.
My learned senior defense has stated they have fairly that impugned no clean career image, fairly, is placed under superannuation. It's 1 lakh of submission. But if you lordship go through the FIR lost by their concerned authority in the page 33 and XRK, only 2 line I will read, my lord. Only 2 line. The very contradictory stand of the part of the FCI, my lord. They have said that, however, the matter of tampering of the date of birth came to the knowledge of this office only on 29/7/21, that is just 1 day ahead of this retirement. Accordingly, superannuation order so and so issued only, sorry, my lord, prior to it. If the actual date of birth of the Sri Deepak Sarkar is 24/7/61, he should retire on 30/7/21. However, the matter of tampering, this word first time used, my lord. One place they have said it genuinely, fairly, that impugn order plus superannuation. One place they have said it, the matter of tampering of the date of birth came to the knowledge of this office on 29/7/21, that is prior to issuance of the impugn order, my lord, just 1 day ahead of the retirement. The superannuation order so and so. I'm pausing, my lord. If the, my lord, one instant they are saying that superannuation order, they genuinely they issued that order, but here they have using the word the tampering. If the tampering word used after the rendering of service of more than 33 years, that inquiry has to be conducted. That fair of opportunity is to be given to the petitioner for natural justice accidentally violent. If the word they using the tampering of date of birth, this is the absolutely contradictory stand they have second. And moreover, my lord, so far as Mikon, since it is their record, the custodian, it is their the authority of the keeping all these facts, my lord, records. I'm not a sufferer. If my learned friend, right from the beginning, saying this tampering. For this purpose of tampering, whether they have formed any committee to inquire, appointed any inquiry authority to conduct all these issues? No, admittedly not, silent. But 33 years, after 33 years of rendering service, without conducting the inquiry, without giving fair of natural justice, how they can issue such an impugn order? Absolutely silent on this point. And so far as Miyot, the delay the approaching before the Supreme Court in paragraph 24 of our petition, we have categorically stated why delay occurred not in paragraph 24 of it. Kali Milot marked paragraph 24. In that petition, we have explained Milot since 2000, paragraph 24 of our petition Milot. When we received that impugn order, from that onwards, one after another, that RTI application, complaint, these are I'm going to file, they refuse without getting all these testimonials. I cannot approach before this court. So by the time this can be genuine and bona fide reason, my lord, thus this attempt has taken place, my lord. And moreover, my lord, my learned senior friend has shown that the previous to the petition casual employee, my lord, in the Annexure D document, Annexure D, my lord, in the page 18 of the affidavit in opposition, my lord, in the clause number 3, my lord, it is clearly written that petitioner is the FCI service on casual service. It is not disputing fact, not suppression of any fact. It is open. It is records. Official records is very much there, my lord. The FCI casual employee with effect from 4/4/78. Since then, he has been continuing in the post of casual order. But this is the order. I am here, my lord, for regularization from date of regularization, my lord, but date of that is written 24 July 2020, 1968.
No, what they mean to say is that you were appointed on casual in
Well,
1978.
casual, my lord. What happened?
But that has been.
Yeah. So, my lord, casual employee, it is the corporation, anybody they welcome, then you come and do help us this thing. But I am concerned about service period is 1987 regularization. This is therefore, my lord, this interview board held and interview board raised certain question and therefore asked the authority if comply all these formalities and after satisfying all these things, my lord, they have given me a point. My friend, my lord, is the case of violation of absolute natural justice and already done citations. I have relied on the apex court and high court. No such inquiry conducted, no such fair opportunity given, and at the fag end of them, that they have this impunity that given without giving me opportunity. This is the respectful submission.
Mr. P.K. Dekar for the issue. Mr. Alamobang for the respondents. Order is reserved.
Your Honor.
Deep law.
She's Ms. Shaukin.
And Chopin from.
And Lord.
Alamobang and Chopin from. You record their names.
Yes, my lord.
Thank you, Your Honor. Thank you for that.